May it please, Lordship. Lordship, I beg to mention items.
Yes.
Yes, Lordship, I beg to mention here in item number 29 and 30. Lordship, let this
Item
matter,
29 and
29 and 30. Let this matter released after 2 weeks, Lordship.
okay.
After 2 weeks, Lordship.
You are for the petitioner.
Yes, Lordship.
Okay.
I am for the petitioner in item number 30. And for the respondent in item number 29.
Okay.
Yes.
In 29, have you informed the other side?
Yes, yes, Lordship. Yes.
Okay, Mr.
The blue marble, Lordship.
On the consent of the other side, praise for listing this matter
After 2 weeks, Lordship.
after 2 weeks.
Lordship.
The prayer is allowed. List this matter after 2 weeks. In both the cases, huh?
Much
In,
obliged,
in one,
Lordship.
Mr. Mr.
The blue marble, Lordship.
He, in 29, you are for the petitioner.
No, for the respondent number 4.
Okay, for the respondent number 4.
29.
And in 30 is for the petitioner, huh? Mr. So-and-so, for the respondent number 4 on the consent, huh? And in the 30, Mr. So-and-so on the consent of the other side. Land council for the petitioner on the consent of other side, huh? Okay. Okay,
Marshal.
Lordship, I beg to mention item number 5. Lordship, let it come out after 2 weeks. I want to file an affidavit in this. I am for the Union of India, Lordship.
not ready for, okay,
5.
it's a short matter. You are for,
I am for the Union of India.
no respondent, and
Well, responding yes.
you're for the
I'm for the
petitioner.
petition.
Is there anything much here to,
I just want to file a short affidavit, Lordship. I am waiting for the signature only because the signature has to come from the Delhi. So I'm waiting for the signature only.
hmm,
Because on the last occasion, I was instructed to file a short affidavit. So I'm just waiting for that, Lordship.
when do you want?
After 2 weeks, Lordship.
After 2 weeks.
If-
Okay. Okay,
Lordship, if the matter can be listed after 3 weeks, then the Lordship, 2 weeks.
2 weeks.
Yeah, Lordship, and has some difficulties, Lordship. And since this is your own matter, on the next day, it can be disposed of.
Yes.
Instead of adjourning the matter.
That is why,
Yeah.
if you're available this week also, we can fix it.
Because the signature has to
The
come
problem
from
is,
me.
because my problem is that I don't know when I will receive the
Yeah.
signed affidavit.
So let it be listed after 3 weeks, my lord.
Heard, Mr. Learning Council for the petition. I've also heard Mr. Ezimomi, you are for respondent number,
For the state respondent, Lordship,
state
1 to 4.
respondent. And,
And Angami, not.
oh,
not
sorry,
Zimomi, Lordship.
sorry, Angami. Jimomi and Angami, and sorry. Okay, Mr.
Yeah, what is for the Union of
Yes. Learning Council, Standing Council for the Union of India. Stop is prayed for by the Learning Council for the parties. List is matter after
3 weeks, my lord.
3 weeks. Okay.
Okay.
May I please, Lordship? I may be allowed to mention item number 10, my lord.
10.
Yes, my lord.
Hmm.
I may be given 2 weeks time to file my affidavit in reply.
Reply affidavit to, okay. To respondent number 4,
Yes, my lord.
okay. Mr. No, we have his name, huh? Land counsel for the petitioner, prays for further 2 weeks' time to file affidavit in reply to the affidavit filed by respondent number 4, stop. Mr.
Abel Amy.
For the land counsel for the respondent number
4.
4 is also present. The prayer of the land counsel for the petitioner is allowed. List is matter after
2 weeks, my lord.
2 weeks. Okay.
Obliged, my lord.
May it please your lordship. May I beg to mention item 24.
24.
Here for respondent number 1. Currently allow 2 weeks time to file counter affidavit.
Okay, you are Mr.
Makaka.
Who is for the revision petitioner? Okay. Mr. Is
Mahaka.
prayed for by Mr.
Makaka.
Mahaka. Land counsel for the respondent number
Respondent number 1, your lordship.
1. 2 weeks time is granted to file affidavit. Okay, stop. List is matter after 2 weeks.
Oblige.
Yeah, please, Lordship. I beg to mention item number 23, Lordship.
23.
Lordship.
You are for?
For the
petitioner.
petitioner, Lordship.
Okay. And,
Lordship, I'm appealing for respondent number 1, Lordship.
okay,
Lordship, I'm appealing for the perform respondent 3 to 6.
okay.
Lordship,
You have no objection.
No, Lordship.
You are praying for how much
2
time?
weeks, Lordship, 2 weeks.
For what? File affidavit.
No, Lordship. Notice for respondent number 2 is still awaited, Lordship.
Notice for respondent number?
2.
Yes, 2 is not appearing. Okay. Mr.
Lucknow from Lordship.
Land counsel for the petitioner. And Mr. Medabiro. for respondent number 1 and Mr. Land Council for the respondent number 3 to 6. Stop. The notice upon the respondent number 2 is still awaited. Is prayed for by the Land Council for the petitioner. List is made after 2 weeks.
2 weeks, Lordship.
3,
2 weeks.
2 weeks. Okay.
Lordship, there's an interim. Interim
Interim.
order.
The interim order passed earlier shall continue till the next date. Okay.
Obliged, Lordship.
May I please, Lordship. Lordship, I beg to mention item number 11 and 12, Lordship.
11 and
12. On behalf of the counsel for the respondent, private respondent, Lima Wapang, Lordship. Lordship, I pray that this matter may come after 1 week, Lordship.
so you have to file affidavit in reply. So you are for?
Respondent, Your Lordship. Private
Okay,
respondent.
who is for the petitioner?
Lordship, and for the
Petitioner was to file affidavit in reply.
No, Lordship, won't file.
You will file.
No, won't file.
You will not file.
Yes, Lordship.
Okay. Mr. You are
Nisuka Chishi, Lordship.
Nisuka
Chishi, Lordship.
Chisi. And counsel for the petitioner. And Mr. Medevuru.
On behalf
Land, land counsel for the respondent. All the respondent
private
number,
respondent, Lordship. Private respondents.
or private respondent. Okay, there is a petition. Stop. Is prayed for by the land counsel for the party. List this matter after 2 weeks
1 week, Lordship.
or 1 week. Okay.
Obliged.
Lordship.
Lordship, I'd like to mention item 16 on behalf of additional AG, Ms. V. Sokre. She's indisposed, so if the matter could be
On
listed
behalf,
after
of,
additional AG, Ms. V. Sokre.
okay,
Pray that the matter may be fixed
Lordship,
after 3 weeks.
This is a condemned matter.
return service report is still awaited here in this case, I think.
Lordship,
So you're mentioning 16.
Yes,
this
Your
is a
Lordship.
condemned petition, Lordship.
16.
Mention. Mention.
They should appear for all the respondents, Lordship.
Respondent number 4.
1, 2, 3, and 4.
I have instruction to appear for respondent number 4.
Well, you are appearing for respondent number
Yes,
4.
yes, I have instruction to appear.
Okay, so sir. Yes, it will still.
Lordship,
he is
kindly
appearing.
consider one aspect of the this condemned petition filed in the year 2022
Hmm.
for non-compliance of the court's order. Now, time and again, the respondents are seeking time that my case is under consideration. However, nothing is placed on record till date. How far the consideration is going on. So, Lordship, my brier's direction may be issued to file an affidavit, detailed affidavit. Whether my case is under consideration or not. What's the condemned, Lordship?
Yes. So. How many respondents? You are for respondent number? No, there is only 2 respondents.
Engineer in chief and chief engineer of the PWD, Lordship.
Well, 3 also, engineers. 3 also impleted, but that there is no respondent number 4. Service of notice issued upon.
My learned friend is appearing for respondent number four.
Lordship, I'll be appearing for respondent number 4, Lordship.
Who is respondent number 4?
Respondent number four is the newly implemented.
Engineer in chief, Lordship.
Chairman
No, Lordship.
Hussaini, and then there are only 3 respondents here in this case. I could find. Fine, whatever it is.
Lordship, I file in IE for implementation of respondent number four.
Okay. So
Which
it
was
has not
allowed
yet
by
been
the clerk of-
incorporated, not yet been impleted here.
Implemented, Lordship. By the order of this court.
Where is IA? Where is the
Lordship,
IA?
yes. Lordship, by order dated 21/8/23. Bus in IE, Lordship,
98.
98/23.
Yes. ITM, Chairman.
No, Lordship.
Just a minute. This is 21/8/23.
Yes.
Since the present incumbent, Chairman has been replaced by engineer Ukonizo Kera.
Yes.
Hmm. We included the respondent number 4, but then of course not yet incorporated.
And my learned friend is.
Registry has not taken steps, and then probably you also need to file amended course title
Already filed, Lordship.
already filed. Then why it has not yet incorporated? Okay, it is in the.
Court
yes,
title,
it is in
amended
the
court title.
It is in a separate sheet, yeah, just a minute, yes, there is. Hmm. Pardon, Mr. Non-counsel for the petitioner. You are appearing for,
Additional AG, Ms. V. Socrates. 1, 2, and
appearing for 1, 2, and
3.
3, Mr. I have also heard Mr. Sanso appearing, non-counsel appearing on behalf of Sokri, V. Sokri, additional AG, land counsel for the respondent number 1, 2, and 3. And Mr.
Kiangami.
Kiangami, counsel for appearing, land counsel appearing on behalf of the newly implemented respondent number 4. So both have not yet filed in the affidavit.
The case is under consideration, Lordship. There's a huge numbers involved.
Okay,
So all of them are sent together in bulk. So
under consideration.
yes, is for
We don't
compliance.
file affidavit, Lordship, highlighting all these
You,
facts.
you file in affidavit, of course, if it is under consideration also,
It is under consideration.
then you
Lordship.
see
So
on the plea that it is under consideration, you can't take adjournment all the time. So it seems 2022. File affidavit,
Lordship.
okay. The land counsel for, so the respondent has not yet filed an affidavit and praise for,
Lordship, 4 weeks in that case, Lordship.
praise for 4 weeks time to file affidavit. Okay. The prayer so made by the land counsel for the respondent has not been objected to by the land counsel for the petitioner. Accordingly, the prayer is allowed. List this matter after 4 weeks.
Lordship, Lord.
Okay.
Your Lordship, I have a similar prayer for item number 20 on behalf of additional AG.
We also condemn petition, Lordship.
For item
Item 20.
20.
Yes, Your Lordship.
Same respondents.
Okay, same respondents. The similar order.
Yes. What was
You
passed in the.
file affidavit.
22.
Here also, I think you are representing.
No, Lordship.
Not here.
I have not instruction to appear in this case.
Okay, so Hmm. So you have not yet filed affidavit.
No, I believe not,
File affidavit,
Your Lordship.
grant 3 weeks.
4
Okay.
weeks, that.
4
yes, Your
weeks.
Lordship, Yes.
Okay, so here. Okay, 3 weeks, huh? Sorry, 4 weeks, 4 weeks. Similar order, huh? Of course, his name will not be there now. Okay,
Your Lordship, I'd like to also mention item 26. On behalf
26.
of, yes, additional AG, V. Sokre.
Hmm.
She has instructions to appear for all the respondents. So kindly grant 3 weeks to obtain the necessary instructions.
Okay, Mr. You are willing, you are?
Subramati.
Okay, then counsel for the petition.
Yes.
Your Lordship, I have instruction to appear on behalf of respondent number 3.
You are for 3,
Yes, Your Lordship.
and then you are for 1 and 2.
Yes, I think so.
I've also
Filing
heard-
my vakalat nama during the course of the day.
Hmm?
I'll be filing my vakalat nama
Vakalat,
during the
okay.
course of the day.
Mr. Learned Counsel appearing on behalf of Ms. Sokri, additional AG, appear for Learned Counsel for the respondent number 1 and 2 staff. Miss
Alitosu,
would appear on behalf of
respondent
the
number 3.
respondent number 3. And both file affidavit.
Your Lordship, I'll be filing my vakalat nama
Okay,
today.
and some is that she'll be filing her wakalat nama within a week, stop. List is matter after 3 weeks.
3 weeks.
Okay, in the meantime, the respondent shall file their affidavit. Okay.
Much obliged.
Your Lordship, I'll also like to mention item 33 from the hearing list.
33.
On behalf of additional AG, V. Sokre. Pray that the matter may be fixed after 2 weeks.
Here for the petition.
Appellant. May it please your lordship. Lordship, wide order dated 30/10/2023.
Hmm.
This honorable court has directed the appellant for dusty service upon respondent number 1.
Hmm.
Your lordship, we have tried every possible means to hand over the notice. However, we are unable to locate respondent number 1,
Hmm.
who is the plaintiff in the money suit. Lordship, a detailed report has been provided by the railway authorities. And as such, we are filing the report during the course of the day.
Okay. Or Mr. You are? No,
No, also on behalf of Nuksum Tila.
okay. Appearing on behalf of Noksung Tila, Learned Counsel for the appellant. Also heard Mr. Learned Counsel appearing on behalf of Ms. Sukri, Learned Counsel for the respondent number 2. How many respondents are there? You are appearing on behalf of respondent number, how many?
Yes, not aware, Your Lordship.
Not aware.
Yes, sir.
33, item 33. So executive engineer, general manager, not aware. Sukri appear for 2 and 3.
Okay.
On behalf of Ms. V. Sukri, Learned Additional Advocate General, correspondent number 2 and 3. Stop. The Learned Counsel for the petitioners submits that. So. Sorry, just a minute, huh? The office note dated 6/11/23 indicates that the service of notice upon the respondent number 1 return. Oh, sorry, still awaited only.
No, Lordship, it has been completed. We are filing a detailed report during the course of the day. A report
Okay.
submitted by the railway authorities.
Okay, then the service of notice upon the respondent number 1 not completed. And you are filing a
Yes, a detailed report
detailed report about
from the railway authorities.
Okay. And the petitioner is filing detailed report. Detailed report from
The railway authorities.
what? What
We
would
are
be?
for the appellant, the railways
Yes.
of the Dusty Service, Lordship.
Okay. The service was caused by Dusty.
Yes.
Okay. The Honorable Counsel for the appellant submits that the detailed report about the Dusty service shall be filed when? Within a week,
During the course of the day.
during the course of the days. Stop. List is matter after
2 weeks, Lordship.
is prayed for by the Honorable Counsel for the parties. List is matter after
2 weeks,
2 weeks. Okay.
obliged.
Lordship, I would also like to mention our item number 37.
37.
Yes. Lordship, here I'm for respondent 1,
Hmm.
the claimant respondent. Lordship, I pray 2 weeks time may be granted. Item 37.
Who is for the petitioner? Appellant. Mentioning 37.
I'm applying for appellant, Lordship.
Okay. Who is the counsel for the appellant?
Lordship, designating counsel is Tayong Juba, Your Lordship. Tayong Juba.
Trying to buy? You are not appearing.
No.
Okay. Mister?
No also on behalf of respondent 1.
Okay. On behalf of respondent number 1, praise for how much time?
2 weeks time. Lordship.
2 weeks time to praise for adjournment.
Yes.
Adjournment of
Yes.
this. 2 weeks time. Praise for listing the matter after 2 weeks. No one appears, none appears on behalf of the appellant. Stop. The prayer is allowed. List is matter after 2 weeks. Okay.
Obliged, Lordship.
May I please, Your Lordship?
Hmm.
Your Lordship, I beg to mention hearing item 34.
24,
34, 34.
34. Okay.
Your Lordship, if the matter may be listed after 2 weeks.
Who is for the other side?
Lordship.
Okay.
34.
Miss. You are Miss
Conley,
appearing on behalf of Saint
Senti
Younger, Land Council for the petitioner. Praise for listing this matter after
2 weeks.
2 weeks. To which Mr. Write his name and Land Council for the state. The state council has no objection. The prayer is allowed. List this matter after 2 weeks. Okay.
Lordship.
Your Lordship, same prayer for item 39 as well.
39.
Yes, Your Lordship.
Okay. Who appears for the other side in this case?
Lordship, I'm for the private respondent number 2.
You're for private respondent.
Yes, Lordship. Respondent number 2.
Okay. You have any objection? No.
No objection, Lordship.
Miss her name, huh? Land Council for the appellant. No, it's a revision petitioner. Huh? Praise for listing this matter
2 weeks.
after 2 weeks. To which Mr.
Mr. Kajish, your lordship.
Learned counsel for the respondent number 2 and the state council, there's no objection. The prayer is allowed. Please this matter after 2 weeks. Okay.
Pleasure.
Lordship, I beg to mention item number 29, Lordship, on behalf of Imti Imsong.
29,
Lordship,
already mentioned.
then Lordship, item number,
Lordship, I beg for your indulgence in item number 29 and 30, Lordship. This was mentioned earlier by the respondents. Lordship, they prayed for 2 weeks' time, Lordship. However, Lordship, my senior will not be available for the month of February, Lordship. So if this matter can come up on the 4th of March, Lordship, I have,
It's a fixed
this
matter.
was mentioned, yes, Lordship. This was mentioned in our absence, Lordship, earlier, so.
Oh, they had a consent. What it is written, item 29 and 30. So whether he's he's there.
Lordship, he is in the other courtroom, but I have taken his consent, Lordship, to fix
Yeah.
the matter for 4th of March.
Okay, then next time he again will come. There was no consent.
No,
So
Lordship, I
back,
have taken his
2
consent.
weeks is a 4 week, huh? 4 weeks,
4th of March.
4th of March.
Yes, Lordship.
Okay,
Lordship,
4th of March will be, okay, on the consent of Mr., huh? His name will be written. Or Mr. So-and-so. And Miss
Miss Lucino for the petitioner, Lordship.
for, you are for petitioner.
Yes, Lordship.
Okay. Petitioner first, huh? And Mr. So-and-so. Line counsel for the respondent, huh? And you are also appearing here.
Lordship.
Okay, for the state respondent, huh? Is prayed for, no objection, fixing mode. Okay, is prayed for by the line councils for the parties. List this matter on 4th March. Okay,
Lordship, I have a similar prayer for item number 36 as well, Lordship. Here also I'm appearing for the petitioner. Item number 36.
36 for the petitioner.
Yes, Lordship.
Okay, when do you want?
4th of March, Lordship.
4th. So here, who appears for the state?
Yes.
Okay, similar order, change the name, 4th March, So. No objection on 4th, no?
Yes,
4th, okay. Miss so-and-so and Miss so-and-so for the state respondent, is grateful by the Dana Council for the
This person to provide your email ID that was or possible.
4th March. Okay,
Highly obliged, Lordship.
Yeah, please, Your Lordship.
yes,
May we please to mention item number 9. Your Lordship, here I'm yet to receive instruction, Your Lordship. So another 3 weeks will be granted, Your Lordship.
okay, you have not yet filed affidavit here.
Yes, Your Lordship. The state.
So who is for the petitioner? In item number 9. She's praying for some more time because they are yet to file affidavit. Okay, Miss,
Levika, Your Lordship.
Why don't let it be the last chance?
No, Your Lordship, I have not received instruction, Your Lordship.
not yet.
Not yet received instruction.
Or is this case of 21? Raise for 2 weeks' time to obtain
3
instruction.
weeks, Your Lordship.
3 weeks' time to obtain instruction and to file affidavit.
Yes, Your Lordship.
Mr. Zhao, Land Council for the petitioner is also present. Please this matter after 3 weeks. Okay. You're also here.
Correspondent number 1, Lordship, we have already filed that.
Okay, okay, that's fine. Yeah,
Lordship,
Miss, also present on behalf of respondent number 1. Okay.
Your Lordship, I also beg to mention item number 31 and 32, hearing item number. Your Lordship, today I'm having difficulties, Your Lordship. So if the matter can come up next week, Your Lordship.
Okay, so who is for the petitioner here, 31
My
and
lord.
32?
My lord, can it be a fixed matter?
Yes, Your Lordship, no problem.
When?
Somebody died way back in 2016 and I'm bringing your lord only for inquiry. CBI inquiry, not the police inquiry. Because he died in the lockup.
When do you want?
Let it be convenient days for my learner free, but let it be a fixed item. My lord.
Six, your lordship.
6th of
February, your lordship.
February. Okay, Mr. MT Longchair, Land Council for the petitioner. And Miss
Levika, your lordship.
Land Council for the respondent number.
Yes, state responding, your lordship.
Hmm?
State responding, your lordship.
No, state respondent. There are other respondent also.
My lord.
Okay. And Mr. appearing on behalf of the Union of India, staff is prayed for by the Land Council for the state. List is, okay. As prayed for by the Land Council for the party, list is matter on 6th to 2024. Okay,
As fixed item,
as a fixed matter. Okay.
my lord. Much obliged.
May I please? Lordship, I beg to mention item 38, Lordship. Hearing. I pray that this matter come after 2 weeks.
Who is for the petitioner hearing the 38?
Lordship, I have a serious objection because this matter is pending since 2022 and there's some urgency in the case. Because of the pending case, it's a 2016 case, Lordship. Because of that, the criminal case.
This is,
My
this was filed in
promotion has
22,
been,
22.
yes, no, the case is 22, but the FIR was registered way back in
Okay.
way back in 2015. And because of the pending case, my promotion could not be considered, my transfer has not been considered. That is why
No, this is criminal revision.
criminal revision, Lordship.
Yes.
Yes, we are challenging the investigation because no sanction has been sought as per the Armed Forces Special Act.
Okay.
Without sanction of the central government, the proceeding the investigation has been carried on. So we are saying that without sanction of the central government, no proceeding should proceed.
Okay.
That's very simple ground.
So, short date,
Lordship.
A short
would
date,
that-
Lordship.
2 weeks time, Lordship.
1 week, Lordship.
one.
Because this is a 2015 case, Lordship.
Lordship.
Okay, so. Okay. Land Council, Mr. Land Council for the respondent praise for listings is matter. After
After a week.
a week.
After a week.
Mr. Gauhati, Land Council for the petitioner is also present. List is matter after a week. Okay, obliged.
Lordship, no further adjournment, Lordship. Because the matter is 2015 case, Lordship.
So this shall be the last chance.
It's
You
a
have hearing on
2015
that
case,
too.
Lordship.
Okay,
Long pending case, Lordship.
okay, hold on. We'll take up the matter on that day.
Lordship.
Okay,
Not Lordship.
Lordship, I beg to mention item number 7 and 8. It's an analogous matter.
item
7 and 8.
7 and 8. 7 and 8. You want to file affidavit?
Lordship.
Amended petition also filed.
They have filed the amended petition, Lordship.
Already filed.
Yes, lordship.
They have already filed.
Okay. Miss Rosina, Land Council for the petitioner and Mr. His name, Land Council for the state respondent,
Lordship.
Okay, stop, is prayed for by the Land Council for the respondent. List is matter after
After 2 weeks.
2 weeks.
3 weeks.
3 weeks.
Lordship.
In the meantime, the respondent shall file their affidavit. Okay, if any, huh?
Lordship.
The affidavit, not if any, affidavit, okay.
Right.
Obliged.
May I please, your lordship?
Hmm.
I beg to mention hearing item number 35. Lordship, I'm appearing on behalf of Mr. Tombok Pongonar. Lordship, please list the matter after 2 weeks.
No objection. Miss, yeah, you are Miss?
I'm appearing on behalf of Mr. Tombok Pongonar.
Okay. Appearing on behalf of Mr. Tompo Pongner, then counsel for the petitioner, raised for
2 weeks.
listing this matter after 2 weeks, to which Miss and counsel appearing for the state has no objection. The prayer is allowed. List this matter after 2 weeks. 2 or 3?
2.
2 weeks, okay.
May I please, lordship? Lordship, I beg to mention item number 19, lordship.
19.
Lordship, here I'm appearing for respondent 1 and 2.
Order only.
So here I'm appearing for respondent 1 and 2, lordship.
Hmm.
So if this matter may be listed after 3 weeks, lordship.
Who is for the petitioner here? Make appellant. Who is for the appellant here?
Lordship, they are not present with the lordship.
Okay, Mr. You are Mr.
Lakshmi Pom, lordship.
Okay, then counsel for the respondent number
1 and 2.
1 and 2, praised for listing this matter after
3 weeks, lordship.
3 weeks. No one appeared on behalf of the appellant, so the prayer is allowed. List this matter after 3 weeks. Okay,
Obliged, lordship.
yes.
May I please, Lordship?
Hmm.
Lordship, I beg to mention item number 15. Lordship, here, there is an error in the PIMS of the petitioner. So kindly grant me 3 weeks time to make a necessary rectification.
You are for
For the petitioner, Lordship.
petitioner.
Yes.
So affidavit and the respondent also not yet filed affidavit.
Your lordship, considering the case of the petitioner, your lordship, we found that like there was an error in the PIMS. So we asked the petitioner to rectify that.
Okay,
So they are taking steps on that, your lordship.
okay. Is prayed for by Mr.
Our semi Lordship.
Land counsel for the petitioner. List this matter after
3 weeks, Lordship.
3 weeks. Okay, Miss. You are for respondent number?
For all the contaminants.
Okay. Appearing on behalf of all the respondents, he is also present. List this matter after 3 weeks. Okay.
Much obliged.
Yes.
For motion, item number 1.
May I please, your lordship?
Yes, please.
There is a checkered history of litigation starting from 2021. I would like to summarize a brief background before I come to the present case, lordship.
Whether limitation applies here?
No, your
Limitation
No,
There-
your lordship.
not applied. Okay.
Lordship, this matter is arising out of a church dispute in the church. That is Oka Town Baptist Church. There are 3 cases, but all 3 cases are passed in a command order. So I will refer to the first case, the item 1. Oka Town Baptist Church was established about 100 years back, 103 years back, 106 years back. And then initially the town was small and the congregation was also small. It was a small church when it was initially started, a century year back. But then in due course, the town also developed and population also increases, believers also increases, like that the size increased. Now the present Oka town is a very big town. Now in view of expansion of the town, the believers, they are scattered even in the every nook and corner of the town. Therefore, it was not possible to have command worship only in one place where it got started. Initially, it was started as Uka Town Baptist Church, and this church is under the umbrella of Luther Baptist Churches Association. The Luther tribe is under the umbrella of Luther Baptist Churches Association. So Uka Town is one of the churches under that Luther Baptist Churches Association. So it is consisting of so many churches. Uka Town Baptist Church is one. Probably it will be the biggest church also because it is a town, district headquarters of Uka. Now, sometime in 2016, in view of expansion of the town, the people who are residing in the away from the main town, they would like to establish the separate church. And in fact, the fellowships were established. And
This was under Woka Town Baptist
Baptist
Church.
Church, yes. And then fellowships were established. There were 3 separate fellowships under Uka Town Baptist Church. And all these fellowships are under the umbrella of Uka Town Baptist Church. But then since a lot of inconvenience were there to attend the churches regularly in the main town, these separate 3 fellowships wanted to be separated and form as independent churches. So discussion was on and on. Way back in 2016, resolutions were taken for establishment and recognizing the 3 fellowships as independent churches. But then a resolution was taken that, look, we have centenary celebration in 2019. Therefore, it will be more appropriate to allow independent status after celebration of the centenary, that is in 2019. And the centenary got celebrated in 2019. But then the resolution could not be implemented to accord independent status to the 3 fellowships. And then in the meantime, before any decision could be taken, Lordship is well aware that the COVID-19 pandemic has hit the world and in India, lockdown was declared sometime in the middle of March. 26 March was the lockdown declared all over the country. So the movement, everything was restricted, so nothing could be done. When the situation got normalized, the people can go around. So the 3 fellowships has approached the mother church, that is Uka Town Baptist Church. Look, we have already taken few resolutions to grant independent status after the centenary celebration. But that has not been implemented. Our resolution has not been implemented. So please implement the resolution. But then matter got delayed. Meantime, some sort of a virtual law and order problem in the town. Because among the believers in the 3 churches, some wanted to remain with the main town, the mother church, and majority wanted to be independent, as had been decided in the general meeting of the Uka Town Baptist Church. It was 2-3 resolutions were taken to grant independent status, but that will be implemented after the centenary celebration in 2019. But that was not implemented, so the believers were approaching the mother church that please implement our decision like that. But then nothing could be done. So there was a virtual law and order problem. So early part of 2021, the Deputy Commissioner convened a meeting in the town that consists of all the Luther Huhu, Luther Mothers Association, and then the Luther Students Union, and the Uka Town is formed in the land of 2 villages, the village council of Uka village and the Longsa village, and then all the sector chairmen all stakeholders were invited by the Deputy Commissioner for a meeting so as to maintain a congenial atmosphere in the town. And then so as to find a resolution and solution to the ongoing problems in the church between the mother church and the three independent churches. So the Deputy Commissioner passed an order fixing two timings in the three fellowships that look, whoever wants to be independent, this is timing, two time slots were allotted.
So it is within one church? No, the place.
The three independent,
The
three churches.
Three churches demanding independent is within the same compound,
No. In the same town,
same town,
different colonies,
or different colony.
outskirts colonies,
Okay,
who are finding it difficult to come to the mother church
okay.
because initially town
How
was
to establish the independent church?
not yet, but I'll come to that point.
Okay.
So DC has passed an order fixing two timings
Hmm.
for the three fellowships.
Hmm.
That was challenged by the Okatown Baptist Church, the mother church, saying that, look, this fixing two timings for the church worship has violated our fundamental rights, and without our knowledge, this decision was taken. That was the plea taken, and a writ petition was filed before this High Court. This Honorable Court issued notice, and then when the matter was pending in the month of August 2021, the Luther Baptist Churches Association, that is the ethics body of among the Luther Baptist churches, Luther Baptist Churches Association has issued an order granting independent status to the three fellowships. So now, in view of the order passed by the Luther Baptist Churches Association, the three independent churches became independent churches. In other words, well, initially they were under Okatown Baptist Church, but the Luther Baptist Churches Association has granted independent churches to the three fellowships, and after that, they became independent churches.
What are the name of these three independent churches demanding?
One is Samyan Baptist Ekumko,
Samayan.
Tichupanza Baptist Ekumko, and then Tichan Luther Baptist Ekumko. These are the three fellowships initially, and in the year 2021, in the month of August, these three churches, fellowships, have been declared and recognized as independent Baptist churches under Luther Baptist Churches Association. Now, since they were recognized as independent churches by the Luther Baptist Churches Association, after their recognition, the matter came up before this court for hearing. But by that time, since we were already granted independent status, a submission was made that, look, during the abundancy of the writ petition, the Luther Baptist Churches Association has granted independent status to the three churches. Therefore, the matter which has been raised in the writ petition
See,
has
this Lota is not with the Wakatown.
My Lord, Okatown Baptist Church is one of the churches under Luther Baptist Churches Association. It is like CNEI, Council of Northeastern Baptist Churches. Under that, there are so many church associations like that. Among the Luthers Baptist churches, the Luther Baptist Churches Association is the apex body under whose jurisdiction all the separate churches are there. So these three fellowships, which was initially under Okatown Baptist Church, was recognized as independent churches. Therefore, they became independent by the time the matter came up before this Honorable Court for hearing. So we inform about the subsequent development which has taken place during the pendency of the writ petition. to the effect that, look, we were granted independent status, so there is nothing left to be considered in this petition. However, the deputy commissioner has seized the keys of the churches, so that may be directed to be released to the
Which
three
churches? Three churches?
churches, yes.
So three churches are in different location.
Yes, different locations, different colonies
Okay.
in Okada. So this prayer was made that Deputy Commissioner Oka may be directed to release all the keys of the churches of three independent churches.
Hmm.
This honorable court has passed that order directing the Deputy Commissioner to release the keys of the three churches. So it was accordingly released. Trouble started. The convener of the legal cell of the Okatown Baptist Church has submitted the letter to the representation to the Deputy Commissioner saying that, look, the order passed by this honorable court directing the Deputy Commissioner to release the keys of the three churches means only the keys of the churches should be released, and it should not include the keys of the Sunday school keys, pastor keys, and other properties. That was the interpretation he tried to project to the Deputy Commissioner, and pursuant to that representation, Deputy Commissioner has issued an order to the three churches saying that, look, the High Court order directing to release the keys do not include other keys. It only talks about the keys of the churches only, not the other keys. That is how DC interpreted. So there was a virtual law and order again. Therefore, we came before this honorable court. We were the respondent in the case because the writ petition was initially filed by the Okatown Baptist Church. We came before this honorable court that, look, the representation filed by the convener of the legal cell Okatown Baptist Church has misrepresented to the DC about the keys, because when this honorable court passed an order directing the Deputy Commissioner to release the keys of the churches, pursuant to that order, the Deputy Commissioner has released all the keys, church key, Sunday school key, pastor's residence, all other properties key, punch was released. Only when the convener of the legal cell submitted the representation, DC has changed his mind and tried to interpret the order passed by this honorable court saying that, oh, no. Keys of the church means it is only the keys of the church, not the other keys. That is what he tried to interpret. Therefore, we came to this honorable court by filing a review. Said, look, to us, it is very clear that keys of the churches, and DC has, pursuant to the order passed by the honorable court, has released the key, entire key. Therefore, it is only trying to twist. The DC is just trying to twist basing on the representation submitted by the convener of the Okatown Baptist Church. Otherwise, the order was very clear without any ambiguity. That was the ground we have taken in the review. And in fact, I believe that that is correct interpretation because DC has already released initially the entire key. Now, when this review was disposed of, this honorable court has in categorical terms said that keys of the churches includes all the keys, including apartment key, Sunday school key, pastor's quarter, everything included. That is what this honorable court gave a direction. However, an observation was made by this honorable court because the petitioner raised a ground that, look, they are saying that it is their property, but it is not their property. It is our property only. They have no right. That point was raised during the final hearing of the review. But this honorable court said that no, this high court is not the appropriate forum to decide with regard to the rights, title, and properties. Therefore, aggrieved party may approach civil court having competent jurisdiction. That was the clear direction given by this honorable court. Therefore, entire litigation with regard to the case, everything is settled. and finalized by this honorable court. But then, basing on the direction passed by this honorable court with regard to the properties, aggrieved party may file a suit in the civil court. In terms of that direction, they have the present respondents, they have filed a suit before the district judge Oka, claiming rights, title, and interest on the properties of the three churches. And this point will be very important, Lordship. Before this honorable court, who were the parties? The parties were Oka Town Baptist Church was the petitioner, and the three independent churches were the respondents. And the review was also filed by the three churches, not any individual, not any person. By the three churches, the review was also filed, seeking clarification of the order passed by this honorable court, which this honorable court has so correctly decided. Now, in the suit, while filing the suit, the present respondent as plaintiff filed the suit, and in the said suit, three individuals who are the present appellants, petitioners, were implicated as defendant number 1, 2, and 3. Therefore, we file an objection, we file an application under Order 7, Roll 11 for rejection of the plaint on the ground that, look, the plaintiff number 2, who is the convener of the legal seal of Oka Town Baptist Church, he do not have any personal rights over the property because property belongs to the church. No individual has the ownership over the property because this honorable court said in categorical terms that parties may approach the civil court with regard to the title and property in question. Therefore, the plaintiff number 2 do not have individual right to claim property of the church. Because in the relief, it is clearly mentioned that plaintiff's direction should be issued to the plaintiffs, declaring the ownership over the property. That is the property of the three churches. So plaintiff number 1 is the Oka Town Baptist Church. We have no dispute with that. But plaintiff number 2 is the convener of Oka Town Baptist Church. By individual capacity, he has filed. So we filed this. Secondly, another point. There are many points, but I will highlight only 2 points. Secondly, this honorable court directed that the parties may approach the civil court. It was the parties. Then who are the parties? It was the Oka Town Baptist Church and the 3 independent churches, as Lordship were asking, inquiring initially. Not any individual. But then in the suit, they have implicated 3 individuals as the defendant. Therefore, by filing the application under Order 7, Rule 11, we raise objection that, look, there is non-jointer and misjointer of parties because we cannot represent the church unless we are authorized. That was the plea we have taken. I'm an individual. I'm only a believer and member of the church. I'm neither a deacon nor a pastor. I have no authority to represent, but you have made me represent the church. I have no authority. That was the plea we have taken in the.
On what basis they have implemented the individual person? So they must have
Yes,
represented, they must
exactly,
have
Lordship.
represented
I will
somewhere.
come to that. The basis is, look, you have represented in the review before the High Court.
Okay.
That was the ground they have taken.
Mhm.
And the learned court below, the district judge Oka has also taken the same ground, which the plaintiff has taken the plea in the reply. But on that point, my submission is, look, in the High Court, before the Honorable High Court, we represented until authorization by the church, we represented. because church as a whole cannot come. There has to be somebody who should represent the church. And the church has authorized the three individuals, three independent churches, has authorized three individuals, different individuals, to represent their church. That's how they represent it. But before the trial court, before the district judge, in the civil suit, we cannot represent because we are not authorized. Mere authorization.
Who is the normal, who normally is the authorized person to represent the church?
As per the High Court order,
Hmm.
it is the church.
Hmm.
And the church should appoint someone who should represent.
Who normally?
Normally pastor,
Pastor.
normally pastor.
Hmm.
And the deacon board is also there.
But in here, in the present case, they
Individual-
already represented the church before the High Court.
Before the High Court, the three churches,
Hmm.
three independent churches
Hmm.
has authorized one person each to represent. And that representation is only for that litigation, only for that review application, for filing the review application. And
So the title suit filed before the district judge was not in continuation with the direction of the.
exactly, Lordship, that is the point. That is altogether a separate proceeding. Therefore,
Hmm.
if they implicate the church as one of the defendant, definitely after getting the notice, church will take a decision who should represent the church.
Hmm.
Because the order of this honorable court is the churches, the parties. Who are the parties before the High Court? It is the church. Kindly come to the review, Lordship. The review, page 115. I will show who are the parties before the High Court. And these parties should be the parties who should approach the civil court. Shamyam Baptist Ekamko, number one. Number two, Tochapansa Baptist Ekamko. Number three, Tiechan Lutha Baptist Church Ekamko. These are the parties. And the defendants were number one and two. And three, up to three is the individual capacity. They are the members of the legal committee. Four is Okaton Baptist Church, five State of Nagaland, six Home Commissioner, seven Deputy Commissioner. So they were the parties. And who is aggrieved, he should file a suit. And the parties were, those are the parties. And the three individual persons who are implicated as defendants in the suit are met in individual capacity. Lordship will find in page 22, annexure A, who are the parties they have met in the civil suit.
So they said that representing the Samian Baptist Ekamko. Representing.
Yes, they are
So
forcing
the
us to
Pansao
represent.
also represent the Chupangju. And Pansao only represents Chechen Lotha.
Yes, Lordship, actually, what they should have done, Samyan Baptist Ekamku, so and so. And after getting the notice, they will nominate a person who should represent. Because parties should be the church, not the person, individual person. It is the church because the dispute was between Okaton Baptist Church and the three independent churches before this honorable court. And so without considering the objection raised, the learned district judge has rejected our application basing on the plea taken by the plaintiffs. Therefore, we approach this honorable court by way of filing an appeal under section 96, read with order 43 of the CBC. For there, this honorable court has summarized the entire facts. 2-3 pages are there. Lordship may kindly come to page
So,
199. 199. This is the order initially passed in the MAF 1 of 2023. Relevant portion, Lordship, may kindly come to
199.
199. It
Okay.
starts from 199, but the relevant page 200.
So this was passed in what? Which?
This was
civil suit?
passed
In the
in
civil suit.
MAF. No. This
No, this-
was an order passed in an appeal filed by the present petitioner
The appeal was against what? Which order?
against the rejection of our application. So
Your
kindly
application- your
come to
application was
page,
for?
kindly come to page 200.
Okay.
The third para. Here, let me read out this. Here, this honorable court has projected the entire background, and I will just refer to your lordship the relevant portion only.
Hmm.
Page 200. May I read from the last paragraph?
Yes.
Relevant one. It is submitted by learned senior counsel for the appellant that the respondents number 1 and 2 of this miscellaneous appeal have filed a civil suit before the court of learned district judge Oka, implicating the present appellant as one of the defendants in his personal capacity. The learned counsel for the appellant has submitted that the relief sought for and the grievances raised by the respondent number 1 and 2 in the suit filed by them before the learned district judge Oka is against 3 independent churches, namely Shamyan Baptist Ekamku, Tichu Yanza Baptist Ekamku, and Tiechan Luther Baptist Ekamku, which were earlier the fellowship of Oka Town Baptist Church and later on were given independent status on 14/8/2021 by the Luther Baptist Churches Association, and thereafter it got its independent status. This is important. It is submitted by the learned senior counsel for the appellant that there was previous litigation between the above named 3 churches as well as the Oka Town Baptist Church in the High Court, and in the said litigation, namely WPC 69 of 2021, and thereafter in Civil Review Petition 3 of 2021, which was filed in the said WPC number 69 of 2021, as well as in IA Civil 13 of 2022, which was filed by the Oka Town Baptist Church. The present appellant represented one of the review petitioner, which were the independent Baptist churches named herein above. It is also submitted by the senior counsel for the appellant that in the civil review petition number 3 of 2021 and in IA Civil 13 of 2022, as well as in WPC 69 of 2021, the present appellant represented the 3 churches on being authorized by the said church. And the appellant did not contest in the said litigation in his own individual capacity. That's very important. However, it is submitted that in the civil suit filed by the respondent number 1 and 2, which is registered as civil suit number 1 of 2023, the present appellant has met the defendant along with other 2, namely Yampansao and Monsao Ngoli, in their individual capacity, and on that ground, the present appellant filed a petition under Order 7, Rule 11 of the Civil Code of Civil Procedure for rejection of the plaint, and by the ambient order, the said application has been rejected by the learned district judge Oka, mainly on the ground that the present appellant were the parties in the civil review number 3 of 2021 before the High Court. Further, the learned senior counsel for the appellant submits that the learned trial court erred in observing that the present appellant was a party as a peer perusal of the cause title of the civil review petition number 3 of 2021. this is what I have just referred to, Your Lordship, page 115, would show that it is the church concerned which were made party in the said review petition, and the present appellant took steps in the said review petition only after being authorized by the church to represent the said church. The learned senior counsel for the appellant submits that there is a misjoinder of parties in the civil suit number 1 of 2023, and the learned trial court has wrongly rejected the prayer for rejection of the plaint filed by the present appellant, which has been made in this instant miscellaneous appeal. It is also submitted that the present appellant has been directed to file his written statement in the civil suit number 1 of 2023 on 27/10/2023. However, another petition, namely IA Civil 8 of 2023, is pending before the learned district judge Oka, where a prayer for implementing the pastor of the three churches is made, and the same is yet to be decided by the learned district judge court. The learned senior counsel for the appellant has also submitted that unless the imbued order directing the present appellant to file the written statement on 27/10/2023 is state, it would raise unnecessary complications in the trial of the suit pending before the district judge Oka. Issue notice, those things I'm not referring because these are not relevant. And next page, page 203, last paragraph. Considering the submissions, Lordship, because others are all with regard to the notices. Considering the submissions made by the learned senior counsel for the appellant, also in view of the facts narrated by the appellant in his memo of appeal, as well as in view of the fact that apparently it appears that the present appellant was not a party in the civil review petition number 3 of 2021, and it was the concerned churches who were the parties. It ought not be just at this stage to compel the present appellant to file written statement on 27/10/2023 before the IA Civil 8 of 2023, which is pending before the learned district judge Oka as decided. Therefore, the operation of the imbued order dated 27/9/2023. This is the order passed by the district judge Oka, and we are impugning this order. This is at page 172, but for the moment, is hereby stayed till returnable date. So this has been stayed. The order passed by the district judge has been stayed. But what happened, Lordship? Kindly come to page 205. Annexure
This is appeal.
G. Yes, the same appeal where the order has been passed.
This is appeal.
This
against-
has been withdrawn on the ground that an objection was also raised by the petition.
This appeal had been
respondent.
withdrawn.
Yes, appeal withdrawn.
So this is stay is,
Stay is vacated now. Interim order passed if any stands vacated, page 209. And this was
209.
withdrawn with the liberty to file afresh. And because the defendants, respondents were also objecting that only a revision would lie, not by way of an appeal. Because appeal was filed under section 96 of the CPC, but this was withdrawn with the liberty to file afresh under filing appropriate application.
so
So
you are
the-
challenging by this revision petition, you are challenging the same order.
Yes,
Okay.
because the earlier MAF has been withdrawn,
This was withdrawn.
and while withdrawing,
Let us
yes,
see.
this is the
208.
withdrawal order.
208.
Yes. 208 is the review order. It was withdrawn on 7/12/2023.
7/12. Yes, 7/12/2023.
Yes. By this order,
Hmm.
we have withdrawn, and by the same order, the interim order which was passed earlier has been vacated, Lordship. That's why it is necessary to stay the present imbued order.
So the only course of remedy available to the appellant would be a proceeding under section 115 of the code. The three appeals upon withdrawal. So you have come by way of this revision
Yes, Lordship.
under one,
Under Article 227, read with Section 115 of the CPC, Lordship.
so you think that it fulfills the requirement or the ingredients of the 115
Yes.
revision.
Yes.
So, but in under 115 of CPC, there is a limitation again. Revisional jurisdiction
Yes.
has a limitation. Hmm?
Lord Chairman, can you see the proviso of Section 115?
Yes,
Provided,
revision
yes.
115.
115.
Yes.
Provided that the High Court shall not, under this section,
You are reading revision.
yes, Section 115 revision. Clause 1, proviso, yes, proviso. After clause C,
For proviso.
provided that
Just a minute. Huh? Yes. So
provided that
let us read from the beginning.
the High Court may call
Hmm.
for the records of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears to have exercised a jurisdiction not vested in it by law,
Hmm.
or to have failed to exercise a jurisdiction so vested, or C, to have acted in exercise of its jurisdiction illegally or with material irregularity.
So you-
Partially, material irregularity is also attracted here. The High Court may make such order in the case as it thinks fit. Material says something, but by ignoring all these materials,
no,
the decision was taken
So
and
where-
provided that
hmm.
the High Court shall not, under this section, vary or reverse
Yeah.
any order made
Hmm.
or any order deciding an issue, this is important, in the course of a suit or other proceedings, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. Clause 2. The second part of this is if in the event of dismissing the suit,
The High Court shall not, under this section, vary or reverse any decree or order. Yes.
and when there is no provisions for appeal, and if the order is to touch and defer by dismissing the suit, then this honorable court will have the jurisdiction.
Now, what, in your opinion, whether the district judge has exercised a jurisdiction not vested in it in this case?
Question of jurisdiction, I'm not.
No, in the
hammering
revision,
on
you see,
that.
you have just read the revision jurisdiction of the High Court is limited
To
to the
have
jurisdictional error only.
acted in exercise of its jurisdiction
Yes.
illegally or with material irregularity.
Yes. Then these three are of jurisdictional error only. That is, jurisdiction not vested in it. The district judge has exercised the jurisdiction not vested in it, one.
Yes.
And number two, his jurisdiction failed to exercise a jurisdiction so vested. Two. Okay.
Yes.
And then the third one is acted in exercise of its jurisdiction illegally or with material irregularity. This is jurisdiction question only. So in the present impugn order,
While exercising the jurisdiction,
yes,
if there is material irregularity
yes,
in exercise of the jurisdiction,
Hmm.
then High Court can interfere.
What is the material? What is the material
Material
irregularity?
irregularities are the name of the parties. These are part of the record. Who are the parties? It is clearly mentioned in the review application. And those points we have raised before the trial court.
Is that a material irregularities?
Yes, that can be considered as one of the material because it is materials and record.
Non-joinder, misjoinder, or party only.
This has been ignored. Suppose, Lordship, another aspect.
No, let us understand that.
Non-jointer and misjointer of party cannot be a ground.
Now there's two A and B goes, it appears. Jurisdiction not
Yes.
exercise a jurisdiction not vested in it. You
Yes, that
don't have
goes.
problem. You don't have any problem.
Yes,
You don't have that question.
yes.
And then fail to exercise his jurisdiction so vested. That is also not in your case. But then you are taking this ground, number C, to have acted in the exercise of a jurisdiction illegally or with material irregularity. Let us know what is a material irregularity.
Now,
What comes? What are the things which comes?
let
under
us
this?
first come to the plaintiffs.
Yes.
There are two plaintiffs.
Hmm.
One, Okaton publishers who have no objection, no issue with that. Number two, the plaintiff number two is in the individual capacity.
Hmm.
In the individual capacity, who happens to be the convener of legal seal of Okaton Baptist Church. If we look at the prayer of the plaintiff, in the plain, they have made a prayer to declare the title in favor of the plaintiffs. So if any title is declared in favor of the plaintiffs, the property will go to him. Whereas there is not even a whisper in the entire plain that he is one of he got the title, he has interest. There is no pleading at all.
No. So,
So those are the points we have raised before the trial court.
so they mentioned a church represented by these individuals.
How? In what capacity I can represent the church? Unless first,
As you represented in the High Court.
Lordship, first let us start with the proceeding in the High Court.
Hmm.
In the High Court, it was the churches who were made parties, not the individuals. It was the church who has made party. Notice was issued to the church. Church has got the notice and they had the meeting and they have nominated and authorized some persons to represent the church. Therefore, they have represented the church in the High Court.
You are representing the church.
Until authorization.
No.
Yes.
No, for the time being, in this case, you have represented the church in the before the district court.
No. Because of that, we have filed that.
In the capacity of?
Individual capacity.
No. You are filing in the individual capacity.
Yes. Because I cannot represent the church. That application has been rejected. The district judge has directed me to file written statement by 27th of October 2023. When I am not authorized at all, in what capacity I can file the written statement? That is how we came before this court. I have no interest also in the disputed property. That is between Okataon Baptist Church and the three independent churches only. But they had met me as a party. So I raised objection, no.
Supposing if you think that you are nothing to do with the case, and if you don't file, what would be the result? If you don't file any written statement, what will be the implication? What would be the result or adversely affecting your individual life?
No, so far as my individual life is concerned,
Hmm.
in no way I'll be affected.
Okay.
But how I have been conferred the authority by the plaintiff to represent a church. On what capacity? Therefore, the plaint should have been filed against the three churches. So I raised that objection before the trial court. No, you have met me as party in connection with the property dispute, but I'm nobody.
What a trial court says then?
Trial
What
court-
justification the trial? What
Yes.
justification the trial court has given?
Can we come to page 172? I will just take your lordship to the relevant portion only, the direction. Page 182, relevant portions. Paragraph 24. This is the same.
Just pause for a minute, huh? So you are representing?
Your Lordship, I'm representing the respondents numbers 1 and 2. That is the Wokaton Baptist Church, Soren Bungo. And Your Lordship, I have many clarifications, important clarifications to make with regard to the facts.
No,
Yes.
just a minute, huh? So you are petitioner there.
Yes, Your Lordship, and the petitioner in the
Petitioner.
civil suit.
So that's just one small question, in the meantime. So when they reject that he is not representing the church, why you did not make the church as a party?
Your Lordship, I'd
Why
like to
you
state,
did not impede the church? As a
I'd
party?
like to state 2 points, Your Lordship.
Hmm.
Firstly, in the eyes
Just
of
to
the
that, just question.
Yes, Your
In the
Lordship, in
meantime,
the
because
eyes
we are,
of the Wokaton Baptist Church, there's no such thing as 3 independent churches.
Hmm.
So what we've implemented them firstly in the individual capacity because they're representatives of minority groups within the congregation that have declared themselves as independent churches and seek to wrest away the properties of the Wokaton Baptist Church. So we've implemented them as representatives of their groups and also in their own individual capacity. That's number 1. And this
okay,
can be
so
seen.
you mean to say that these individuals represent not the pastor or the churches, as you don't recognize them as a church?
Yes, Your Lordship, we don't recognize them as a church, number 1. Number 2, they're representatives of groups that are seeking to wrest away the properties of the Wokaton Baptist Church. And if Your Lordship looks at page number 37, Your Lordship, of this revision petition, Your Lordship, page number 37, which is in the civil suit. Page number 37 at paragraph 6. We've stated over there, Your Lordship, that it is only some of the congregation, that is the persons named the defendants numbers 1, 2, and 3 in the instant suit, and their groups who are attempting to wrest the property of the Wokaton Baptist Church. So the plaintiffs have no objection to the aforesaid defendants establishing their own churches. However, by claiming to establish new churches, they cannot be permitted to illegally take away the properties of the Wokaton Baptist Church. That's point number 1, Your Lordship. And secondly, Your Lordship, since the petitioners in the instant revision petition, Your Lordship, they've been adopting delay tactics, Your Lordship. They've been filing.
Okay, just because that was only to be clarified why you did not impede. So
Yes, Your Lordship.
Okay, just a minute.
However, Your Lordship, there's
Okay,
also.
you take your seat. Let him complete. Okay.
Yeah, but second point, Your Lordship,
Hmm.
we've also filed an impediment application in the lower court as a matter of abundant caution, since they've taken
Impediment petition in the same type
in the
suit.
same civil suit, an impediment, yes, application seeking to impede the persons whom they say are also representatives of their parties.
That is an afterthought. After we file the objection only, they have filed that application also. That is pending. Still.
Okay.
And now,
Yes.
Lordship, first point which my learned friend has raised.
So no, this is with regards to the party.
Yes.
And then necessary or the joinder of or non-joinder of the necessary party or joinder of
Yes.
the
Misjoinder and non-joinder.
misjoinder of the party. So does it, is this question or is the material comes under the material irregularities?
Lordship, when this honorable court has categorically mentioned the parties, who are the parties, that is important. An order passed by this honorable court is a law. And this honorable court said the parties,
No.
agree party, the parties, who are the parties? That is relevant. Who are the parties? Parties are Okaton Baptist Church and 3 independent churches. My learned friend has made a submission just now that we don't recognize these 3 churches as churches. That is why we implement in the individual capacity.
As you
If I have
represented
understood
there,
correctly,
as you represented in
if
the
I
High
have
Court.
understood correctly, she has made that submission.
Hmm.
If that is so, accepting that submission, if we are not recognized churches, on what basis you have filed a first writ petition implementing the church as a party? That is the writ petition 104. Starting point from it starts from there.
So
On one hand, they are saying that we don't recognize, but
no, this is
by recognizing
say for example, Mr. Sumongo Obong.
Yes.
They say that representing the Samian Baptist Ikumko.
On what capacity I can represent? Why they are making us
Representing.
like to represent the church? What is the basis? They should be able to explain. And the explanation they have given, we don't recognize the church as a recognized church. Then it is you who has implemented the church as party in the initial proceeding.
Your Lordship, we've implemented them as
Is it not
representatives
contradicting themselves?
of their groups, Your Lordship.
What group? Let him explain. On one hand, you are filing the case against the church. At the same time, you are saying that we don't recognize as a church.
Now, can you just try to satisfy the court the material irregularities which comes under? So if this question of the non-joinder or misjoinder of party is a material irregularity.
Lordship, before that, kindly come to page 182. The ground on which the conclusion has been arrived by the learned
182.
182, paragraph 24.
This is order passed by, okay, the district judge.
Twenty-four, Lordship. It is seen that this is not a ground for rejection of this
It is seen that it
are
is
the
not a
same
ground for
parties who in civil review petition 3 of 2021 were allowed to approach a civil court of confidence having jurisdiction to decide the dispute over the properties by the Honorable High Court. Considering the pleading made in the plain, the relevant documents enclosed along with the plain and submissions made by the parties, it is seen that the serious question of law and facts are involved in the suit at hand, which requires detailed consideration. Under the circumstances,
you are reading 25, para?
Yes, 25.
Okay.
And then continuation. And in the last 2 lines, Lordship will find list for filing of written statement by the applicant's defendant on 27/10/2023. I have been directed to file written statement. So when I am not the authorized person, court is forcefully forcing me to file the written statement. Under what authority, under what capacity I can file?
What if you don't contest the case?
No, to contest the case, who am I?
What if you don't contest?
They are forcing me to contest the case. Who am I to contest that case?
Now, I'm saying, just asking. So what if you don't contest the case? does it adversely affect you?
I as an individual will not affect.
Okay, then,
But they are forcing me to file the written statement on behalf of the church. We are raising this point, pointing out
no,
this
if the
objection.
church doesn't come,
Let the
if
proper
the church,
party be
if the
updated.
church doesn't come, if the church failed to come, then
Lordship,
church will face, church if there is, will face the consequences, not you.
Lordship, church was not made a party.
No, the church, if thinks that the title suit or the suit has been filed, civil suit has been filed against them, and they are not been made party, the church can also intervene.
Definitely.
Yes, but if the church is not doing that, so if you are not adversely affected, then why you should contest? Don't contest.
That is why.
Hmm.
That is why I have no interest and I have no authority to contest this case. Therefore, unnecessarily, you have implicated me as a party defendant. That is the application we have filed under Order 7/11.
No, then
Since they have not implicated the proper party, it should be rejected because in the High Court.
then your prayer should have been to strike off your name from the suit, not the dismissal of the petition, if you are not the interested party.
But this Honorable Court said, while disposing the review application, the parties.
Then you are representing the church then.
No. That was, I have represented in the review because I was authorized to represent.
No,
But that is not automatic
if
in
it
the
ends
trial court.
there in the review, till the review, if it ends there, then you leave here. Don't contest.
That is what we have
What
filed the application. That is what we have filed the application. I cannot represent the church, but they are making it in a representative capacity. They have not implicated the church.
No. This,
They are forcing me to represent the church, which I do not have the authority. That is the ground we have raised before the district judge. And this Honorable Court said that the parties, then who are the parties? Before the High Court. Those should be the party even in the suit. But they have not implemented the church as a party.
so anything else in the regarding the material irregularities? Because this probably doesn't come under the material
When
irregularities.
this Honorable Court has.
This is only the misjoinder of party. And then what I have indicated that if it doesn't affect you.
Material irregularity would be on
because-
the plaintiff number 2 also. Because look at the prayer portion, Lordship may kindly see the prayer. What is the relief they are seeking for in the plain? They have sought a decree.
No, you are not connected with that. Then supposing if you think that you are not the relevant party or not the necessary party, you are concerned with that.
I should not represent the church. I cannot represent the church. That is
That is what you're saying.
Yes. And the plaintiff number 2, who is in individual capacity approaching the Honorable Court to declare a decree in his favor
No, but
without
if he-
any pleading.
even if he make any prayer also, since you are not the interested party,
I'm not the right person to represent the church. That is my submission, Lordship. Because when this Honorable Court has clearly directed the parties to approach the civil court having jurisdiction, then they should have implicated the proper parties in the suit. And why they are forcing me to file the WEs when I'm nobody in the case, in the church. I'm only a believer. I'm only a member of the church. At least I should not be directed to file the WS on behalf of the church in absence of any authorization.
Because there is also no material irregularity, it appears, that which will affect the ultimate decision. So material irregularities which will affect the ultimate decision of the case, which will
Ultimate decision
materially
of the
affect-
case would be to declare
Because here
the
is the case where
title.
you are not the interested party, as you said. Okay, yes.
Your Lordship, I would just like to make a few points, Your Lordship.
Please.
Yes. Firstly, Your Lordship, on the previous date, Your Lordship, this Honorable Court is pleased to know that this revision petition was not maintainable, as there was no violation of any jurisdictional issues in the lower court, Your Lordship.
Previous that means here in this case.
In this case, Your Lordship, however, that was not recorded. However, the learned single judge had stated in court, Your Lordship, in open court,
Okay.
that the question of jurisdiction does not arise in the instant case, and hence this revision petition would either have to be dismissed or withdrawn. To which, Your Lordship, the learned senior counsel submitted that he would take some time to consult with his clients, Your Lordship, and so the order is recorded as follows, Your Lordship. The order has been recorded as Mr. C.T. Jamil, learned senior counsel appearing on behalf of the petitioner, submits that he may be permitted to obtain certain instructions as regards the
Yes,
matter.
that is in order, yes.
Yes, Your Lordship.
Certain instructions.
Yes, Your Lordship. And the instructions were whether to withdraw the case or not. But
That I don't have no idea, but
yes, Your Lordship. But that aside, Your Lordship, just a few points, Your Lordship. Apart, I will not go into the facts of the case. So there are a lot of misrepresentations, Your Lordship. Firstly, is that the Wokatown Baptist Church, Your Lordship, it owns these three churches. These are branches of the Wokatown Baptist Church, and they are the Wokatown Baptist Church. The petitioners have not highlighted that all the right title deeds to these properties are in the name of the Wokatown Baptist Church.
just a minute. So according to you, this is under the Wokatown Baptist Church.
Yes, Your Lordship.
Three of these.
Yes,
all
Your
these
Lordship.
three.
And what has happened is that the petitioners and their groups who are minority members of these congregations, they wanted to be independent. They wanted to break away from the church, which we, the respondents numbers 1 and 2, have no problem with. However, the problem here is that they wish to take the property of the Wokatown Baptist Church without its consent in the process. So they've renamed the properties of the Wokatown Baptist Church to the names of Samyan Baptist Ekumko, Chupiangzu Baptist Ekumko, and Tiechan Lota Baptist Ekumko. But the real names of these three branch churches, Your Lordship, are the Wungoju Sector Church, the NST Sector Church, and the Saron Sector Church. And these three churches are the WTBC, and they belong to the WTBC. And the ownership of the right title deeds, everything is in the name of the WTBC. So that's point number
Despite
1.
of the location of these three churches which claim to be the church.
Yes, Your
Its
Lordship.
location is in the different places.
Your Lordship, your Lordship can think of the Wokatown Baptist Church as the main church, and the three other churches are the branch churches. They are all together the Wokatown Baptist Church, like an Axis Bank main headquarter and Axis Bank sub branches.
Okay, the property belongs to the.
Yes, Wokatown Baptist Church. Now, the petitioners also are also stating that the Lota Baptist Church Association, which is an umbrella organization comprising of Lota Baptist churches, has given them independent status, Your Lordship. They've stated that. However, Your Lordship, the Lota Baptist Church Association does not have the authority to transfer the properties of its independent members, Your Lordship. Such a claim is be totally violative of Article 300A, Your Lordship. The Lota Baptist Church Association is simply an umbrella organization. They do not own the properties of the WTBC, Your Lordship. So to say that the LBCA recognizing them as independent churches means that they now own the properties of the Wokatown Baptist Church, Your Lordship, would be untenable in law, Your Lordship. That's the second point, Your Lordship. The third point, and even the Lota Baptist Church Association, Your Lordship, specifically told the petitioners that while they have been granted independent status, they are not authorized to make use of the properties of the Wokaran Baptist Church without its permission. And all of this is on record, Your Lordship, but these are matters which are to be determined by the trial court. So, and then number three, Your Lordship, is that or the application for rejection of plaint, Your Lordship, on the ground of misjoinder of parties, Your Lordship. But for that matter, they haven't pleaded non-joinder, they've pleaded misjoinder. But for that matter, neither misjoinder nor non-joinder is a ground for rejection of plaint. So even in the first instance, Your Lordship, the question of the lower court exercising its jurisdictional powers in an ultra-virus manner does not arise. The lower court made the correct decision in holding that the plaint could not be rejected on those grounds, Your Lordship. That's the first point. And Your Lordship, I have out here, if I could read a case, Your Lordship, on the issue of misjoinder of parties, on whether it should be a ground for rejection of plaint.
That can be, but the man, we have to be concerned.
If Your Lordship is
concerned with
concerned
the
with the,
revision,
yes, Your Lordship, with
whether
regard to
revision lies or not.
with revisional jurisdiction, Your Lordship, if I may take Your Lordship to a case, it's a constitution bench case, Your Lordship, decided in the year 1966 by the Supreme Court. The case is the case is Pandurang Nandi Jogle and others versus Maruti Hari Yadav, Your Lordship. And at paragraph number 10, Your Lordship, the court notes at paragraph number 10, Your Lordship.
Para 10.
Yes, Your Lordship. And this case has not been overruled, Your Lordship.
This case is here. Para 10.
Yes, Your Lordship. Your Lordship, this
Yes.
case has not been overruled and is a leading authority. It states that the provisions of section 115 of the code have been examined by judicial decisions on several occasions. While exercising its jurisdiction under section 115, it is not competent to the High Court to correct errors of fact,
Yes.
however gross they may be, or even errors of law, unless the said errors have relation to the jurisdiction of the court to try the dispute itself, which is not the case at hand, Your Lordship. As clause A, B, and C of section 115 indicate, it is only in cases where the subordinate court has exercised the jurisdiction not vested in it by law, or has failed to exercise the jurisdiction so vested, or has acted in the exercise of its jurisdiction illegally or with material irregularity, that the revisional jurisdiction of the High Court can be properly invoked, Your Lordship.
Yes.
So that's the current position, Your Lordship. So the High Court can only correct, the High Court cannot correct errors of fact
Right.
or law, no matter how
That is true
gross.
in a revision, yes.
Yes, Your Lordship. And so the question of whether the petitioners in the instant case are necessary parties, or whether there has been misjoinder or not, or whether they're necessary parties, whether they're churches, or whether they're minority groups, Your Lordship, are questions of fact which have to be decided by the trial court, Your Lordship. And secondly, Your Lordship, in the instant case, Your Lordship, the petitioners have been filing, there's been multiplicity of proceedings, Your Lordship, all with the intent, Your Lordship, of delaying the process. The civil suit, Your Lordship, if they say that they're not interested, the civil suit does not affect them in any way, Your Lordship. However, they have been continuously trying to stay the proceedings of the civil suit. And as a result, the Wokaran Baptist Church, the rightful owners, have been deprived of their right to use the property, Your Lordship. And so if a stay were to be granted in the instant case, a grave miscarriage of justice would occur, Your Lordship. And as it is, Your Lordship, since the petitioners in the instant case filed the miscellaneous first appeal, which was dismissed, Your Lordship, the case has been stayed because immediately after that, they filed this revision petition, Your Lordship. So the civil suit, the proceedings in the civil suit are in abeyance. So even the impleadment application has not been going through.
Now, so
Yes, Your Lordship, it's still in abeyance because the lower court is of the opinion that since
no, that has been vacated, already vacated.
Yes, Your Lordship. However, since the order which has been challenged has been an order to reject the plaint, the lower court is waiting for the High Court to decide whether
Unless
it
there
will
is
be.
stay.
Yes, Your Lordship. However, they've been waiting for the High Court to decide whether the plaint should be rejected or not, Your Lordship.
Now, Land Senior Counsel, so two options. So what do we do? Either
Firstly,
reject
I
or-
would like to clarify on one or two points. Firstly, with regard to the property, which my learned friend was initially trying to project that this is the property of Okaton Baptist
No, no,
Church.
no, that, we
Lordship,
better
here,
we have to
yes,
here,
here,
to the
Lordship,
revisional
as
jurisdiction
I
of the
have
High Court.
admittedly, as I have submitted initially,
Yes.
it was only one initially.
Yeah.
All of us, whatever the property
That
are
will be
jointly
decided by the
developed
trial
by
court.
all of
That-
us.
That will be decided
So
by the
that
trial
is a
court.
common,
That involves with the fact.
yes, that
yes.
is one.
Mm.
Secondly, how to proceed without a proper defendant? If the case has to be proceeded, there has to be
They'll
proper
take care
party.
of it. The petitioner will take care of that. And probably that petitioner will take care of that.
Let that be properly
Can't-
streamlined.
And the court also can't decide on that count against any, no one. So they'll take care of it.
Thirdly, they are mentioning about the delay, as if we are the party who are dealing the matter. It is because of the lapses delay has been caused. If at all you want to initiate any proceeding, you implement proper party and let the proper proceeding be initiated. Then there can be no delay. It's all because of, if there is any delay, it's all because of
You
the
said that you have
lapses.
already filed
Lapses.
impleadment petition
Yes, your lordship.
that has been disposed of,
No, your lordship,
That
it's
is
still
pending.
pending, your lordship.
still pending. That
Yes,
will be
your lordship.
decided only, I think, in the meantime.
Yes, yes.
That should be decided.
It should be-
Thereafter only, the suit has
You
to be
think that that is
proceeded
the
with the
proper
proper
party
party.
that we have, which you have impleaded?
Yes, your
The
lordship.
party which you have impleaded?
The petitioners, your lordship, in their miscellaneous application, your lordship, in the lower court, they stated that the correct representatives of the churches should be, say, from the board of deacons or chairpersons. So we've filed an application to implead the so-called chairpersons, your lordship, from the board of deacons. Even though we don't recognize them as churches, they have formed their own self-styled organizations and churches. So we've impleaded them in that.
Even now also
Yes,
they are
yes.
contradicting. Lastly, Lordship, this application is not only under section 115,
Okay.
it is an application under Article 227 of the Constitution. And under 227 of the Constitution, the power of this honorable court lordship is heavier.
Right, right.
Its arm is very long. It can go to any extent so as to cure and to interfere with the injustice, lordship. So here is a situation
But
where
since
there is no proper
revision-
party. Court has directed the person who is not authorized to file WEs within a specified time. Under what authority I can represent that? So that needs to be rectified and let the proper party, let the suit be proceed with the proper parties. We are not saying that they cannot file. Let them file, but let it be properly filed and let the proceeding be proper in accordance with law.
Your lordship, if I may make a few points, your lordship, on the submissions of the learned senior counsel.
Yes, sir, please.
Firstly, your lordship, the settled law is that, your lordship, where the jurisdiction of section 115 lies, Article 227 is usually not invoked, your lordship. And secondly, your
We are
lordship,
concerned with the revision.
yes, your lordship. And secondly, your lordship, whether it's Article 227 or section 115, the settled principles for revision are usually the same, your lordship. And thirdly, your lordship, the question of whether they should be necessary parties in the civil suit, or whether they should have to write a written statement. These are defenses and applications they can file in the trial court, in the court of the learned district judge themselves, your lordship. They don't need to invoke the revisional jurisdiction
That
of
is
this
already
honorable court, your
rejected
lordship.
by the lower court.
Your lordship,
That is why we are before this.
their order to reject the plaint was rejected.
Okay, so. So you want the order to be passed by this court?
Let the record be called for and.
No, no.
amend that.
No, under the circumstances, because you have failed to satisfy On what basis, on what ground we call for the records? Records are there.
No, Lordship, assuming that if
Hmm.
Lordship is
You
interfering
have
with
not
the
satisfied the
order
3
passed by
matters.
the
You have
district
not
judge
satisfied the 3 matters. because-
directing me to file the WS. Under what authority I should file when I am not the authorized person, when I'm not the owner of the property, how I can file the WS and contest the case on behalf of a church? I'm an individual only. That lacuna should be rectified first, Lordship. Let this honorable court say that in view of this, you are present,
No,
but that cannot be.
revision,
Yes.
revision cannot be.
So then, how can I represent the church? If we are to comply with the direction and order passed by the district judge, when I'm not authorized, the suit has to be proceeded without a proper party. That
So,
should be corrected
there is
first.
2 options, what I'm saying, there is 2 options, either you withdraw or I'm dismissing the case. Dismissing the revision petition. It stays. You have not satisfied
Then,
the 3 matters.
in
Required.
that case, the lordship is accepting the fact that even if I'm not a proper party,
Hmm.
then I should file the WS and then contest the case.
No, there you see,
That objection I have raised
the op-
before the court.
that option
The
is
court has already
with
arrived
you.
to a conclusion on
Hmm.
that point. Court has
So
already arrived to a
that option
conclusion
is
that
with you. That option is
you
with
file
you.
the WS.
That option is with you. And then they have also filed impediment petition.
Let that be heard first. After hearing that, who should file the WS will come, the issue of that will come. So let that application be heard first. And then if that is allowed,
No, what application
Then-
is to be heard? On what ground?
Lord Chief, that application is IA Civil 8 of 2023.
Hmm?
IA Civil 8 of 2023 that is pending. And this honorable court on an earlier occasion, on 13/10/2023, this said observation has been made that is pending. If that application is allowed, then that person will be the proper party to file the WS. So it will be 2 parties again. If the order of the district judge is to be complied with by the ambient order on 27/9/2023, I have been directed to file the civil suit. Another application is pending before the same court for impleadment of the party. And if that person is directed to be impleaded as a party defendant, then there will be 2-party defendant to defend the one church. Who is the proper party? That is to be streamlined first. Let that be decided first. Thereafter, who should be the proper party to file the WS will come. That is how I'm before this honorable court. And this honorable court can, in exercise of power under 227, can rectify all this.
Your Lordship, if I may kindly make a few submissions.
Yes.
Firstly, Your Lordship, the impleadment application pending in the civil suit, Your Lordship, it has no, it has no bearing on this revision petition, Your Lordship. This revision petition is for completely different reasons, Your Lordship. And number 2, Your Lordship, if this revision petition were allowed to continue like this, it would cause a multiplicity of proceedings, Your Lordship, which would overburden this High Court, Your Lordship, this Honorable Court, Your Lordship. Thirdly, Your Lordship, it would cause great hardship to the respondents, Your Lordship, who have been saddled with a lot of inconvenience and legal fees, Your Lordship, and also a lot of mental agony.
Lordship, may you kindly see page 184. That is the application.
What is that?
That is the application filed by the plaintiff. IA civil number 8 of 2023. This is filed under Order 1, Roll 10, Clause 2 for impleadment as defendant number 8, 9, and 10. So this very fact shows that they have committed a mistake initially in filing the suit by impleading those persons. And this application has been filed only when we raise objection by filing an application under Order 7, Rule 11. Is it not an afterthought? After we raised the objection, only they have filed this application. That very fact shows that they are admitting the fact that they have committed a mistake initially by bleeding their present defendants, and they have filed an application under Order 1, Rule 10, Clause 2, for embezzlement of 3 defendants as party defendant in the case. And this application is pending. And if this application is heard and allowed, then defendant number 8, 9, and 10 will be different person again, different authority to defend the case. That is how we are before this honorable court, Lordship. Even there are defects in this application also.
Okay, I'll pass order then, if you are. In which page the order, earlier court passed an order in the appeal filed by you?
It's page 199.
Your Lordship, I'd just like to point out a small point, which is that in the appeal, this interim order was granted ex parte, so we were not there we could not defend ourselves. So this order, this interim order was passed ex parte, Your Lordship.
That was ex parte.
Yes, Your Lordship.
No, Lordship. Kindly come to page 202. Last line. As Ms. Losino, Learned Counsel, appears for respondent number 1 and 2. See,
Your Lordship,
contradicting the records.
Your Lordship, the Vakalat
Counsel
Nama,
is making the submission, Lordship.
the Vakalat Nama had not been filed, and so the said counsel was not aware of the facts of the instant case, Your Lordship.
On instructions,
So no
the
proper
counsel has
defense.
appeared. Otherwise, under what authority the counsel can make submissions in their appearance in the court? One should be careful in making submissions, Lordship.
And then 205 is.
Two zero five is the withdrawal order, and
Okay.
interim order has been passed earlier on 13/10/2023, suspending the proceeding.
And can you just show me the ground? So which I can pierce draw in the ground for filing this
Rules, page
revision.
16.
So where you think that it made out the ground under this query?
2 to
Under
7,
revision.
2 to 8, Lordship. Page 16, 17, and 18.
16, so ground 1, 2, 3. How many grounds? Which ground, according to you, is the one which,
It will only take 3 minutes, may I read from ground 2, Lordship.
then the relevant ground, which you
All are
think that-
relevant, Lordship, to me.
Okay,
2, 3, 4, 5, 6, and 8. All are interconnected also, and all are relevant.
These involves with the ground 1, also you talk about a fact. And then, so we are not interfering if it involves with the fact and even the laws, no? Unless it is the 3 grounds for the revision is violated.
If there
Okay.
are material irregularities, then definitely that is a ground to.
Where do we find the material irregularities? In which ground number?
Ground number 3 also I have mentioned.
What
pleaded.
it says?
For that learned court below committed grave irregularity while passing the ambient order dated 27/9/2023 as the plain, which suffers from serious irregularities in regard to misjoinder of necessary
misjoinder,
parties,
no.
was overlooked by the learned court below.
No, misgender is not.
And then ground 2, for that civil review petition number 3 of 2021, the parties were directed to approach the competent civil court, and the parties involved in the disputes are the churches and not individual persons. But the private respondents have implemented the individual persons as defendants, and as such, the learned court
No.
below has not taken that into consideration and passed the ambient order, and as such,
You are taking the misgender.
the ambient suffers from irregularity and is liable to
This is
be.
misgender only. And then?
4, for that the aforesaid civil suit, the plaintiff number 2 represented in his personal capacity and prayed for a decree to declare the rights, title, and interest of the suit property, who has no individual and exclusive right in the suit property and is barred by law. However, the objection raised by the appellant regarding the misjoinder of parties was overlooked by the learned court below, and as such, the ambient order dated 27/9/2023 is liable to be quashed and set
If
aside.
there
by
is
this
also, this
honorable
is
court.
an error of law, if there is any.
Five.
The misgender only, okay, then.
Yes. 5, for that the present petitioner was duly authorized by the member of the Shamayan Baptist Ekamku to file the civil review number 3 of 2021 only. The said authorization does not automatically qualify the present petitioner to represent the Shamayan Baptist Ekamku in the proceed civil suit. This is what I have been submitting. Earlier in the review was undue authorization, but it is not automatic in the civil suit to represent. Just because I have represented
This is
in the review.
misgender.
Yes. Accordingly,
Same thing.
the petitioner filed the proceed miss case contending that he has no authority to represent the Shamayan Baptist Ekimko in the proceed civil suit. However, the learned court below came to its conclusion that the said objection is not a ground for rejection of the plain, since the present petitioner is the same party who in civil review petition number 3 of 2021 were allowed to approach a civil court having competent jurisdiction to decide this dispute over the properties by the Honorable High Court. See, this is the basis that since you have represented in the review, you have every right to respond even in the civil suit. That is the ground where the learned trial court has based her finding. Such erroneous finding is not sustainable in the eye of law, as authorization given by a particular church to represent in a particular petition does not automatically qualify to represent in the subsequent suit. As such, the ambient order dated 27/9/2023 is liable to be quashed and set aside. And then 6. For that, the trial court has erred in law in directing the present petitioner to file his WE written statement on the next date, that is 27/10/2023. Since the present petitioner has no authority from the members of the Shamayan Baptist Ekamku to represent in the aforesaid civil suit, such direction of the learned trial court below cannot be complied with, and as such, the ambient order is liable to be interfered with by this honorable court. It is an absolutely unworkable order, an order which cannot be implemented. So this is illegal. but forcefully I have been directed to represent, to file the WS. So anything which is contrary to law, it is illegal. Therefore, this Honorable High Court can interfere with that. 7. For that, learned trial court passed the ambient order dated 27/9/2023 without applying its mind from the legal point of view, and also by ignoring the relevant provisions of law involved in the instance suit. And as such, the ambient order dated 27/9/2023 is labeled the request. 8. For that, the direction passed by the learned trial court below in the ambient order dated 27/9/2023 to file written statements by the petitioner cannot sustain in law, as the appellant is only a bona fide member of the Shamayan Baptist Ekamku and not a necessary proper party to the pending suit, which is barred by law to file written statement in individual capacity. Those are the points, Lordship. I cannot do anything which is not sanctioned by law. But I have been forced to act by the ambient order that you should file the civil suit since you have represented the church in the civil review. But as I have mentioned several times, in the review application, I have represented undue authorization by the church, and the parties who were implicated in the petition was the church itself, not the individual person.
Okay, I'll pass order.
Lordship.
Okay.
Much obliged.
Who did that?
Much obliged.
The other two
So-
are similar.
Yes, yes.
Come on now.
So, copy is Xerox.
For motion item number 4.
Yes.
Malata, this content arises in this Honorable Court Writ Appeal Order number 3 key of 2018. Where this Honorable Court is directed to consider for illegal discharge period.
So,
Then what happened if you have interpreted it on your own way?
is there any limitation?
No,
No limitation.
this is a.
So when the order was passed,
29/5/2019, 215.
19.
No, I'm under 215 of the Constitution of India. So whatever this Honorable Court order passes,
Okay.
it shouldn't be, it has to be complied. Because when it is under 215, that the question of limitation.
No limitation.
No,
Not 1 year.
no. Malot, when it is a court of recall, something may happen after some years also. But since when this Honorable Court give a direction or order,
Okay, when the order was passed?
Maybe
That's-
that's right.
Yes.
Uh,
29/5.
the petitioner, the
Hmm.
petitioner here, the same petitioner has filed two writ petition, which is still pending against the same order. So whether this contempt petition will be applicable when that petition is
So that-
still pending.
You have filed petition?
There is two
No.
petitions that is
There
still
are
pending.
two petition.
Okay, after the,
Pass,
just a minute, when the order, this order was passed, 29/5/19,
yes.
there are after 19, there is a petition,
Two writ petition is
two
still
writ
pending.
petition for what?
Yes,
My lord,
on the same ground.
one is illegal discharge.
Illegal?
Illegal discharge.
Yes.
Next is whatever debate as per this, their own order, they are trying to recover it, which is not permissible. So this doesn't have any connection with the present.
Just a minute, what is the specific direction in this 29/5 5/29,
My
specific
lord,
direction, which you, according to you is the violation of the order, direction?
page
Relevant portion.
31.
31.
Yes.
Okay, please, let us read.
Thus, we are of the view that the issue of payment of back wages would have to be again considered. However, as
Which
the
paragraph?
my lord, this is
Oh, yes, thus, we
yes,
are of the view.
yes,
This is single bench or
division, my lord.
division bench, DV.
Yes. We find that the learned single judge has not
Just a
made
minute.
any finding with regard to propositions called out by the apex court. Thus, we are of the view that the issue of payment of back wages would have to be again considered. However, as the decision to be made would relate to facts, we are of the view that in the facts and circumstances of the case, the question of payment of back wages, if any, would be best considered by the appellant. Accordingly, appellant 2, that is DG, is directed to consider the payment of back wages to the respondent, if any, for the period 15/5/2010 to 19/9/2015 by keeping in view the propositions which have been reproduced in the foregoing paragraph, in also considering whether the respondent was employed in earning elsewhere during this period of discharge. The appellant number 2 shall take a decision on the question of payment of back wages within a period of 3 months from the date of receipt of CDC of this order. Subsequently, the impugned judgment such and such is set aside.
So they have not taken decision.
My lord, we have taken. Only the thing is that page 32, annexure 4.
As I said, Lordship, there is 2 petitions pending, which is still pending before the Supreme Court. One is for discharge and one is for payment of back wages.
Recovery. No, they are saying that.
So unless there is a payment of back wages in that other case, so unless that is settled, how can there be a contempt?
So that is why I'm saying. So they the respondent,
Right there, only the respondent, they have taken the decision.
the appellant, or the respondent here, shall take a decision. Whether they have taken decision.
Yes,
They have
Okay.
taken this, yes.
What decision was taken?
Page
To pay or not to
32,
pay?
my lord.
And
Taken that.
that order that has been challenged in the second writ petition. Lord.
This order has already been
Yeah,
challenged.
that is in
Then
the
No,
second
my
petition for discharge.
No,
not
For
challenged.
recovery.
no. This is as per the order of the appellate court. My lord.
Yes.
Then what they've taken that decision not to pay the back wages?
No. Where is the direction to pay the way?
Otherwise,
Just a minute.
but just Lordship,
Ah.
if the 2 writ petition, which is still pending, if this can be taken up together, then all the facts will be cleared up.
Yes.
Because it's a question of
yes,
contempt.
Because
And contempt, we have already taken
let
the decision
me
as per the
clarify.
direction of the court. So if this 2 writ petition, along with this contempt be taken up, this contempt petition will ultimately be dismissed.
So you are agreed by this speaking order? Are you agreed by the speaking order? No.
Not a question of my agree for not.
You are agreed by what?
My lord, the
Action.
whole question is your lordship order.
Hmm.
You have misinterpreted it. That
Where-
is the
where?
whole issue.
By which order?
This is
By which order they have
speaking
misinterpreted?
order.
Speaking order.
Yes.
That means you are agreed by this speaking order.
My lord,
Just a minute, just kindly just.
my
Whether
agree.
are you agreed by this speaking order?
No,
No.
my lord,
What?
the writ petition is a different issue.
Hmm?
This is a contempt issue.
No. So whether this speaking order has been passed in compliance with the order of this order and direction of this honorable court, division bench.
Yes.
whether this speaking order, I suppose this speaking order has been passed in compliance with the direction of this division bench order. Is
My
it
lord,
so? Is it so? Are you aggrieved by this speaking order?
my lord, that
Just
will be a
answer-
writ issue.
Just answer.
No, this will be a writ issue.
Huh?
If I want to challenge this, it'll be a
No, no,
writ issue.
Because I have some confusion. Kindly
Yes.
clarify me. So are you aggrieved by this speaking order? Are you aggrieved by this?
My lord, if I am aggrieved, it'll be a writ issue.
No,
but-
you are not aggrieved by this speaking order.
My lord, in this present issue, I'm not saying that it is aggrieved or not aggrieved. The question in the content is whether
no, no.
somebody have complied with the order or not.
Then clarify, where is the specific direction?
My lord,
Which has a specific direction given by the division bench and which has been violated?
my lord,
Kindly read the specific direction and the violation. Tell me the violation where? By which?
page 27.
Page 27.
We have heard learned counsels for the parties. The single judge, the BBC, leave it to the wisdom of the appellants to issue
This is
appropriate
this is
orders.
reference to the judgment of the single bench.
Yes,
Submission, direction, I'm asking you the
my lord,
direction.
this is what this appellate court has come to the
So
conclusion.
that has been quashed, set aside.
No, it
The
Yes,
impugn- the
language,
impugn judgment order
your
dated
lordship
25,
orders.
set aside.
Yes, I understand, set aside, but after hearing the parties, what was the finding of the appellate court? So Paratan may be saying the learned single judge leave it to the wisdom of the appellants to issue appropriate order with regard to payment of pay in allowances to the respondent for the period of his discharge from service. The commandant such and such thereafter treated the said discharge period as dias non. The grievance of the respondent with regard to non-payment of his pay and allowances for the discharge period was adjudicated in the WPC number such and such, when the single judge directed the appellant to pay the respondent his pay and allowances for the discharge period. In view of the above facts and circumstances, we feel it appropriate to refer to the decision of the apex court in Tipali Kundu, wherein the apex court has called out, these are the two grounds, certain propositions while deciding the payment of back wages. The propositions called out by the apex court are produced below. The proposition which can be called out from the judgment of the Supreme Court while deciding the issue of back wages are: one, in case of wrongful termination of service, reinstatement with continuity of service in back wages is the rule, normal rule. Proposition two, the aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee and workman, the financial condition of the employee, and similar other facts. So, page 30, this is the reflection of proposition 1 and 2 in Dipali Kundu. Proposition number 1 states that on wrongful termination of service, reinstatement with continuity of service in back wages is the normal rule. As per proposition 2, the proposition number 1 is subject to what? To the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee, the nature of misconduct, if any, proof against the employee, the financial condition of the employer in other similar factors. And going through the impugned judgment, such and such, passed by the learned single judge, we find that the learned single judge has not made any finding with regard to the said proposition 2. That is the only reason we find that the single judge has not made any finding with regard to
That is why
proposition.
it was set aside.
It is not set aside. My lord, I may be allowed to continue.
Okay.
It has to
No, no,
be as,
come to the last.
yes,
Subsequently, the impugned judgment and order dated 25/7/2017 passed in WPC number so is set aside. What is this then?
my lord, I understand that,
Hmm.
but it is a proposition 2 is clearly indicated how to decide.
So that is why it was set
Yes.
aside. What I'm saying,
My lord,
the
yes.
single bench did not consider. That is
But
what it was set aside.
What I am saying is that the learned appellate court sees that it is to be on the basis of the proposition 2 laid out by the Supreme Court. That means it has to go into the facts in decide. So that liberty was given to DG. Then what happened? Thus, we are of the view that the issue of payment of such and such be again considered, my lord. On what basis? However, the decision to be made would relate to facts. We are of the view that in facts and circumstances of this case, the question of payment of back wages, if any, would be best considered by the appellants. Accordingly, the appellant too is directed to consider payment of back wages to the respondent, if any, for the period from such and such. By keeping in view the proposition which have been reproduced in the foregoing paragraph, that is exactly as per the Supreme Court propositions 1 and 2, which is 1 will be subject to 2. Proposition 2. So it is not that the whole judgment of the single judge was set aside. You have to decide on the basis of the law laid down by the Supreme Court. Then what happened? We decided to pass this page 32. Dated 13 December 2019. May I read out?
It's a long one. Which one you want to read out? The relevant portion?
The Lordship, this is the second time
So that,
no, what I want to say is, second time the matter is listed.
Hmm.
And I do not have a copy of the petition. And I have been instructed to.
My lord,
Yeah.
this is a contempt.
This is a contempt, Your Lordship.
How
I have been
can,
instructed-
no, that is why,
yes,
even to issue the notice, at least we need to know
Yes.
yes.
what is the specific direction. And what is the direction which has been violated?
My lord,
What is the
Lordship,
order?
The direction, it is only a direction. It was a direction to consider.
Yes,
So on the basis of the direction issued by the Honorable Court, we have considered rightly or wrongly. So if
By
they are,
passing this
if
speaking
they are,
order.
if they are aggrieved, they should have filed a
yes, yes.
appeal, not a
Appeal.
contempt.
If
should
you are
file an
agreed
appeal.
by the, if you are
Not a
agreed by
contempt,
the,
Lordship. Because the direction of the court is not to direct the appellant to play, but to consider.
that is why I'm saying,
So
If
if
he
there is
is a-
two words, it's a direction and to consider.
because in pursuant to the direction.
No,
this speaking
my
order
lord,
was
as per the appellate court specific direction, how to consider, It cannot be at your own whims and fancies.
No, please, please
The
answer,
appellate
answer.
court order is direct, but it has to be considered as per the proposition laid
Okay,
down by
let
the
us
Supreme
find out,
Court.
let us find out, huh?
My
The
lord,
thing. So according to you, some direction has been given by the division bench
my
by
lord,
this order.
my lord,
Okay. So that direction is to consider.
my lord. As per
Just a minute, huh?
my lord,
So in compliance of the direction of this division bench, the respondent authority, particularly the appellant number 2, okay, probably has passed this order dated 13 December 2019.
my
This
lord,
is this is
my lord,
speaking order.
my lord.
Now, my specific question, kindly answer, huh? Is whether you are agreed by this speaking order?
My lord,
Okay, whether you have
Because
challenged it,
it is,
whether have you challenged this order?
my lord, challenging will be a question of deed.
No, I'm
Not-
asking you, I'm
not
asking
in the
just simple
context.
yes or no. Don't speak. Whether have you challenged this order?
No,
No, they have not challenged.
no.
We have not challenged.
No,
Lordship.
no.
We have not challenged. So how there will be a contempt when they have not challenged? They have not challenged the order. Rightly or wrongly,
No, no.
an
So
order has
this
been passed.
Two writ petition is with regards to what? Two writ
The
writ petition
first is
filed.
with regard to discharge.
Because you said that subsequently they have filed two writ petitions.
Yes,
What is
yes.
pending
The
before them?
first is with regard to discharge from service.
Hmm.
The second is regard to salary.
Which the charge is subsequent to this order, not connection
Acha.
with this.
You have not challenged this speaking order.
No.
Because this is not against you.
So you have not challenged,
No,
them.
no,
How can there be a
it's not
contempt?
that.
This is not against you.
It's not that.
Just a minute, just a minute. Is it in favor of you or is it in your against?
It's
This
against him.
speaking order.
It's
this is
against
speaking-
him, Lordship.
It's
Against-
partly 6 pay commission is in my favor,
Okay.
but the adjudicated verdict is against me.
But you see, rightly or wrongly, against you or in your favor, but then the respondent authority has passed this order as per the direction of the High Court.
Yes.
They have complied with the order and direction of the High Court. Have they not?
Yes, to that extent.
Okay, then.
But
Then by
what
what
I'm
order-
saying is that
Hmm.
we have misinterpreted the appellate court.
Then how the contempt has been made out?
My lord,
If they have complied, if they have complied.
when-
Because the direction is not specifically to consider positively.
my lord, it is positive for the reason that it has to be under proposition 2 of the Supreme Court. It cannot be what you like. No. The honorable court did not give a
appellant number-
direction, you
the-
pass in it.
Kindly read this last sentence. The appellant number 2 shall take a decision.
Yes,
Kindly read this
yes.
sentence.
How?
Hmm.
As I
Last sentence.
clearly pointed out, it has to be proposition 1 and 2.
Where?
Page 30 is very clear. What is the appellate court order? Yes, I understand that we need to set aside, but it is modification or improvement of the single judge.
So, you are representing,
I was instructed to appear on behalf of the respondents.
respondent, respondent,
two.
how-
1 and 2, yes.
okay, so. You reply then,
My lord.
will issue notice,
My lord.
okay, because I don't see the violation also, but still then, okay, anyway. Hmm. Okay.
Copy and be out.
Ah.
My lord, I may be allowed to furnish
Yes, you
two copies
you
of
furnish.
the response.
Inti Longchair, then counsel for the petition,
applicant, petitioner.
and also heard Mr.
Jamawat.
Appearing on behalf of the
Respondent 1 and 2.
respondent number 1 and 2. Staff, para. This is an application under section 11 and 12 of the contempt of court Act 1971, read with the contempt of court, Gauhati High Court Rules 1977, and Article 215 of the Constitution of India. Where have you said that there is a violation of the order? Where have you said?
My lord,
In which paragraph?
yes. It starts from para
No, where have
5.
you?
My lord,
Okay,
para 4. That against the honorable court judgment in order that is such and such Union of India filed WA such and such.
now where have you said that there is a violation of the order passed by the division bench? Unless there is a violation, there is,
Mal,
there cannot be
my lord,
conflict.
para 5.
5,
Yes. Para 5,
yes.
1,
Hmm.
para 6.
No, no, para 5, where it is said, where you have said that there is a violation. Can you read?
Para 5.
Hmm.
6C, the fact that whether number such and such was employed. This is your finding.
No, no, no.
No,
No,
this
this
is
is- you have
this is
quoted,
the
you have
finding of
quoted.
the
So where have you
respondent.
said?
It's
Where
not
have
an,
you
it's
said?
not an allegation, it's just a finding. There is no allegation from the side.
Where is the, where have you stated that there is a violation of the order passed by the Honorable High Court, Division Bench? Where have you stated? One sentence.
Para 7.
Hmm?
Direction of this honorable court order such and such has not been given.
Para?
Para 7, page 9.
Yes, the direction of the given liberty, given to
Such as
respondent.
has not given any liberty to the respondent but to decide as per the proposition called
Yeah.
out from the judgment of the apex
And,
court.
okay, and
Such and such.
where have you said that they have not decided as per the direction and there is a violation? Where
My
have you
lord,
said?
that in other words, continuation, page 10, this honorable appellate court judgment in order such and such has been totally misconstrued, distorted, shredded into whims emphasis of the respondent with one and only intended motive, that is to defeat this honorable court judgment order dated 29 such and such. All right.
For non-compliance of the
Yes.
direction of the, for non-compliance of the direction of this honorable court order passed in non-compliance of which order? Division bench
Yes. 29/5/2019.
order dated 29/5/2019.
Yes.
Passed in WA 3 within bracket K bracket close / 2018. Stop. Issue notice returnable by 4 weeks. Stop. Mr. His name.
Yang Odi.
Now, since Mr. appeared and accepted notice on behalf of respondent number 1 and 2. No formal notice need be issued to the said respondent. However, the petitioner shall furnish extra copies of the petition to the land council for the respondent number 1 and 2 during the course of the days. Stop. List this matter after 4 weeks. 4 weeks. Okay.
Much supplies.
For admission, item number 6.
Lordship, as per the direction of the Honorable Court, we have already published the notice in the newspaper. I have already found my affidavit
Okay.
that the notice has been published in the newspaper.
Mr. Yamagati.
As of today, none has appeared, so I'm afraid that the notice can be deemed to be complete.
Mr. Yamagati, land council for the petitioner. Submits that as per the direction of this court, he has
Published the notice,
got the notice
published,
published
published in the newspaper.
in the
Yes. As per the direction of this court.
newspaper. Have you filed in the?
Yes, yes, Lordship. Copy. Copy. Newspaper copy. Substitute notice newspaper. Itu tadi. Newspaper lah apa publication.
It's just one. I think.
Yes, yes, Lordship. Yeah.
Okay. As per the direction of this court, notice upon the sole respondent has been published in 2 local newspaper having wide circulation in the state of Maharashtra. On which date it was?
Lordship, the first was is in Hindi, so I'm not very sure, but that's same date is.
On April 20, huh? 20, April 2020. In the Times of India. And
Lordship, one is also the Times of India, but it's in Hindi version. On 2
Okay.
paper, one is in Hindi, one is in English.
and on the same date, in Hindi newspaper Maharashtra Times. To that effect, the petitioner has also filed affidavit by annexing the newspaper publication. The above newspaper publication. Stop. However, no one appears on behalf of
That's all responding.
the respondent. Stop. In view of the above, the steps upon the respondent is deemed to be complete. The next date,
Let it come up for hearing for the initial course, Lordship.
Okay. List is matter after 4 weeks. Okay. List is matter
For hearing in the usual course.
for hearing
For hearing in the usual
in
course.
the usual course. Okay.
Much obliged.
Yes. How many matters we have left?
9 matters.
9 matters left.
Lordship, I beg your lordship indulgence in item 25, your lordship.
25.
Yes, your lordship.
Oh.
I have instruction to appear on behalf of respondent 1 to 3, your lordship. So I may be granted 3 weeks' time to obtain instructions.
Okay. Miss
S. Mary.
S.
S. Mary.
Mary, sorry. Mary appearing on behalf of, who is for the petitioner here? Okay. So she is seeking time.
Yes, Lordship.
Okay. Okay, Mr. You are Mr.
Subhamati, Your Lordship.
Okay, what you calling? Counsel for a petitioner. Miss Mary appear on behalf of the respondent 2 and 3 and praise for
3 weeks' time.
3 weeks time
To obtain
to
instructions.
obtain instruction and to file affidavit.
Lordship.
Okay, the prayer so made by the learned counsel for the respondent has not been objected to by the learned counsel for the petitioner. The prayer is allowed. List is matter after 3 weeks. Okay.
Obliged, your lordship.
May I please, the lordship, in
Yes.
item 21 and 22, I am appearing for the petitioner lordship.
Yes.
This is a restoration petition lordship.
Yes.
So we have filed an application under for delay condonation in the restoration petition lordship.
Okay. So notice to be issued.
Lordship notice already issued. We have taken say nobody appears lordship.
Nobody appears. What next then?
Lordship may condone the delay and restore the lordship.
Item 21 and 22.
Yes, your lordship.
So any other matter can be taken up. If it is to be taken up, then we'll have to resume the case at 2.
Sorry for the small submission, your lordship, for item number 27.
Just a minute, huh? And counsel, just a minute.
Lordship, for the indulgence.
There is a mention, just a minute.
In order item number 27, your lordship.
27.
Yes, lordship.
You're for?
For the appellant, your lordship.
Okay.
Lordship, as per this honorable court's previous order, date 66/11/2023, we have taken steps upon the respondent number 4 through paper publication, and to that effect, we have filed our affidavit.
You have already filed?
Yes, lordship. Our affidavit, lordship. Affidavit.
Okay.
However, it appears that respondent number 4 are still yet.
Okay.
So, whether this matter may come up.
Mr.
Medovero, lordship.
Medovero, counsel for the appellant submits that he has taken steps upon the respondent number
4
by publishing in the
paper publication in Assam Tribune, lordship.
okay, in the newspaper in the Assam Tribune.
Yes.
And to that effect, he has also filed affidavit.
Yes, lordship.
Okay, however, no one appears on behalf of the respondent number
4. So, that may be deemed served, your lordship.
We need to see that. In view of the above, the notice upon the respondent number 4 is deemed to have served. How many other respondents are appearing?
Yes, lordship.
Lordship, I for respondent 1 to 3.
Mr.
No was on behalf of respondent 1, 2, and 3.
For respondent number 1, 2, and 3 is present. So list is made after
2 weeks, lordship. 3 weeks, lordship.
3 weeks. This will be for hearing. You have filed your affidavit?
Not yet, lordship.
Have you filed? Not yet.
Not yet.
Okay, Mr. So and so for the respondent 1, 2, and 3.
Yes. Respondent 1, 2, and 3.
1, 2, and 3. Prays for some more time to file affidavit. The prayer is allowed. List is matter after 3 weeks. Okay.
Lordship, I beg to mention item.
That is Medovero. That is
27, lordship.
27.
Yes, lordship.
Okay.
Lordship, I'd like to mention item number 14, Lordship.
14.
Lordship, if this matter can come up after 3 weeks, Lordship.
Who is for the petitioner?
I'm for the petitioner, Your Lordship.
Okay.
Lordship, in the meantime, interim pass earlier, Your Lordship.
Interim,
Continue,
yeah,
Your Lordship.
okay. Mr. You are Walid,
Gauhati.
Learned counsel for the petitioner, and Mr.
Lijumon.
Jimome, learned counsel, learned state, counsel for the respondent state. Is prayed for by the learned counsel for the party. List is matter after
3 weeks.
3 weeks. Okay.
Lordship, interim, Your Lordship.
In the meantime, the interim order passed earlier shall continue till the next date. Okay. In the meantime, leave. Okay. Okay, then item, yours is item,
18, Lordship,
yes,
item number 18.
18.
Yes, Lordship, the last order says that if the respondent cannot place before this honorable court the compliance order, then the chief secretary will be the respondent. The respondent will have to be present before this honorable court has been passed. So Lordship, they may be fixed. Probably they have not yet complied with the orders of this honorable court.
This is item 18.
18, contempt.
Contempt.
Personal appearance has been passed.
Yes, after this. This is matter after 4 weeks in the event of failing to complete.
The last time was given.
4 weeks. This court will consider. So what is your submission? You are for
I'm for the petitioners.
petitioner and you are for?
Lordship, I'm for all the respondents here.
Okay.
Lordship, in the last occasions, as
Respondents have made the subject matter of the case is now pending for consideration for the state cabinet and the last opportunity may be granted. So what is your instruction now?
Lordship, so far the respondents are concerned. They have already submitted to the cabinet. The cabinet is yet to sit over the issue after passing of this order. So Lordship, I'm limited to have submissions.
So when it was submitted before the state cabinet?
Lordship, this is the fourth round of the cabinet memo has been submitted before the cabinet. In the first place, when it was submitted before the cabinet passed an order saying that, okay, a committee has to be constituted under the chairmanship of the chief secretary and examines all the matters. That is number one. So the cabinet, the committee was constituted and recommendation has been made to consider the issue. Then after that was placed before the cabinet after having perused of the issue, that the prior consultations of the Advocate General has to be taken in that issue. So that matter was referred back to the Advocate General, and Advocate General also, in consonance with the recommendation made by the committee, saying that it has nothing to do with the Article 371 and no infringement to the customary laws. So this can be considered. That is how the Advocate General has written to the cabinet. Thereafter, again in the third place, the cabinet has again referred the matter back, saying that this is one important issue, the state important issue. So the Bar Association, the Bar Association, the High Court Bar Association, and also the Advocate General, that is for the second time, that has to be consulted. So the department had the consultations with the Bar Association. Then even the Advocate General for the second time returned to the cabinet. But after taking the decisions, the cabinet is yet to sit over the issue. That is the only the issues pending, Lordship. Otherwise, see, all the requirements have been fulfilled.
Lordship, this submission has been made before this honorable court is going to be at least a year. The same submission, and there is no proceeding at all. So
Why don't you initiate, why don't you practically
Yes.
instruct or inform the concerned authority?
everything has been done, Lordship. Even the
Yes.
secretary of
And
law
probably
department
maybe-
has been brought before this honorable court in person. Yet there is no.
Maybe the order passed by this court has not brought to the notice of the authority. So
No,
there is,
no,
a-
it
there is,
was.
a- there is
It-
an
it-
order,
it-
list this matter after 4 weeks.
It has
In
been,
the event of failing to complete the process within 4 weeks,
Yes.
this court will consider issuing necessary direction to the respondent to remain present in the court.
yes.
Yes, so
That's
this,
why-
no, no.
Now thereafter,
Yes.
thereafter, have you taken any steps or have you informed the?
Of course, Lordship.
So this order has been passed, placed before the authority?
Yes, Lordship. Even the chief
What is the
secretary,
respondent? What is the respondent now?
the respondents, they have already placed the cabinet memo before the cabinet
No.
for consideration.
Hereafter, within this 4 week, what step they have taken?
Cabinet is yet sitting over the issue, Lordship. That is the only issue. Cabinet.
Now, whether the reminder issued? Reminder,
Even personally, me along with the chief
no,
secretary.
what is your instruction, whether the chief secretary or the
Today-
authority concerned?
Today's
issue-
instruction.
Today's instruction is that to take some more time so that the cabinet will wait for the cabinet to consider the issue. So my limited prayer is,
Now you see, the court repeatedly passed an order, and if you
I have understand.
repeatedly violate or repeatedly you should neglect.
Lordship, taking seriousness of the issue, I have personally went along with the chief secretary and met the chief honorable chief minister because he is the head of the cabinet. But see, the cabinet is yet sitting over the issue. Just that is the issue now. But
Lordship,
I have today too. I have
Now-
not
now you
much
see-
to say, Lordship, since in the last occasion, court
Lordship,
has passed the order.
the chief secretary has been implemented. So instead of the learned council submitting before this honorable court the same thing for a year, Lordship. And if this rule has been implemented since 2017, Lordship, it's now 7 years. Seven years is a long time, Lordship. And all the recruitment, everything has been withheld. So, Lordship, based
Take
on
a
the,
call and take a serious step, huh?
Yes, Lordship.
Now it's time that you take a
Lordship, I admit to that. Lordship.
serious steps.
I admit.
Lordship, in the interest of justice, my lord, be pleased to let the chief secretary appear before this
Same thing,
honorable court.
Lordship, on the part of the respondents.
No,
they
that is, that the respondent has to come and explain before this honorable court, not the learned advocate, because how many times will he submit the same thing before this honorable court? And if this honorable court order is violated up to this extent, where will justice go, Lordship? And what is the use of listing this case before this honorable court?
Okay, what we can do is, because I have not gone through the orders also. So some more time can be given this time.
Lord.
And then in that case, with a specific, of course, you come out with some positive result.
Lordship.
Lordship, this has been going on for more than a year.
Next.
The same thing.
So this time,
I
kindly
understand.
take it as a serious
Lordship.
note from the courts, no? So every time, so this type of order will be there, and then of course the time will adjust. And then the time will come when the court will have no option. But to pass an order, necessary order.
Lordship.
But then don't take it undue advantage of the courts giving some liberty. No?
Yes.
Lordship 2020, 21, 22, 23, 24, 4 years, they have not complied with. This contempt was filed in 2021, Lordship. The order, they withdraw it on 28/8, 2020.
Miss J. Jimomi, Learned Counsel for the petitioner. And Mr. Yor Kakring Ruling. Kakring Ruling, Learned Counsel for the respondent. Mr. Kakring Ruling. Pray for some more time. Which the Learned Counsel for the petitioner, Miss Jimomi, objected. And Mr. Kakiguli, and pray for some more time to
let the state cabinet create it.
for consideration. Some more time for consideration, which is pending before the state cabinet. And cabinet. To which Miss Z. Jimomi has objection that this prayer has been
Going on for a year,
going on
more than a year.
for.
The
since-
same prayer.
Going on for a year, start. The learned counsel for the respondent container will come up with a positive result on the next stage.
And if they don't come up, Lordship has to pass a specific order. How many specific order has to be passed?
In view of the prayer made by the learned counsel for the respondent contemner, least this matter after. So this will be, of course, last 4 weeks. In the event of failing to complete the process as directed by this court, as directed by an order dated 20/11/2023.
The respondent number 1, Lordship, it can be respondent number 3. Since he is the head of the state, maybe
Within 4 weeks, this court will consider issuing necessary direction to the respondent to remain present in the court personally.
Much.
Least is after 4 weeks. Yes, this is item number
21 and 22, Lordship.
21 and 22. Okay.
Let it be await for service report on respondent number 1 and 2 and come after a fixed date, Lordship.
Okay, you have taken fresh steps.
Yes, Your Lordship. We have-
You are Mr.
SS Roy, Lordship.
SS Roy, Learned Counsel for the applicant. Who submits that he has taken steps upon the respondents, Stop. However, the return service is still awaited. It is still awaited.
Yes, Your Lordship.
No. So here this office note 24/1/24 says that the Learned Counsel for the applicant has not taken fresh step for notice upon respondent because by an order dated 28/11/2023,
Lordship, we will again take the step within 2 weeks, Lordship, we will take the steps, Lordship. We cannot check the office note, that's why, Lordship. We will take the fresh steps, Lordship. But as per my instructions, Lordship, it has been taken, Lordship.
No, by an order date, on 28/11/2023,
Lordship.
as per your prayer, you will
Lordship.
take fresh steps upon the respondent
Lordship, I will check it.
with
Check
the
it out.
proper and correct address within 15 days. No? So kindly take fresh steps.
Lordship.
Earlier it returned. Okay. Okay, just then Mr. So-and-so, counsel for the applicant who prays for some more time to take fresh steps upon the respondent
Lordship.
in their proper and correct address. Stop. The steps shall be taken within how many days?
Lordship, within 2 weeks, Lordship.
Within 2 weeks from today. Stop. List is matter after how
4
many?
weeks.
4 weeks. Okay.
Lordship. If Lordship fixes a date, Lordship, as we are the outside.
When do you want? When do you want?
Lordship,
By the council for the applicant list is matter on
Lordship, in the month of March, Lordship, first week.
Okay.
4th of March, Lordship.
4 March. Okay.
Oblige, Lordship.
Thank you, Lordship.
Yes.
My lord, item number 28.
Item
Item number 28.
28.
Yeah, service notice still awaited.
Okay.
So my lord allowed me to give us subsequent notice by way of pause,
By way of
speed pause.
speed post. Okay.
Yeah. Sole respondent.
Hard Mr.
Alvin Zhao.
LV Zhao. Will Zhao, not counsel for the petitioner, applicant petitioner, and submitted praise for allowing him to take fresh steps upon the respondent by a speed post. Stop. The prayer is allowed. List is matter after. The petitioner shall take steps upon the respondent by a speed post within 4 days. 4 days. 4 days from today. Stop. List is matter after 4 weeks. Okay.
Oblige.
Any matter remains? One more. Yes.
Your Lordship, regarding about item number 17, since it's a very short matter, Your Lordship may kindly take up the break.
What is this matter?
Your Lordship, for questioning the FIR on account of the compromise.
Yes, compromise settlement.
Yes, Lordship.
Done.
Yes, compromise has already done, Lordship.
Is it? Give. Item 17. Item 13. 13 also there. Okay, then. Okay. This is 17. 17 is compromise.
Yes, Lordship.
Both parties are present.
Your Lordship, on the last occasion, this honorable court has directed whether the compromise has been executed between the parties to give a report by the learned magistrate court. I'm for the Your Lordship, this is a joint petition, the complainant as well as the accused person.
What petition? Joint petition?
Yes, joint petition. Lordship.
Joint petition filed before this court?
Yes, Lordship.
An application under section so and so. The matter of so and so. Okay. So you are representing both the parties?
Yes, Lordship. Your Lordship, may kindly see my page 14 in Annexure 2.
Page
14 in Annexure 2.
Okay.
Yes, Lordship, this is the compromise that which was made between the.
But the compromise, you see, this 2 of the sections are non-compoundable cases.
Yes, Lordship.
So how it can be?
That is why I'm approaching this honorable court for under 42, lordship,
For,
482 of the CRPC lordship.
have you cited any judgment
Is
where
lordship
it is
may-
allowed?
is lordship may kindly see my 2014 9 ACC. At para 4
What it
lordship.
says, para?
At para 4 lordship.
What it says?
At
Yes.
At para 4 line 7, I may be allowed to read. Offenses which involve moral turpitude.
No. This is Yogendra Yadav and others.
Yes, lordship.
2014 9 SC.
Yes, lordship.
Para 4.
Yes, lordship.
The para 4 is now the. Can you read
Yes.
the relevant portion?
My lord, I'll just read the relevant part. Your lordship may kindly come to line 7.
Yes.
Or line 12, lordship.
Line?
Line 12. Line 12, 1 to 12.
2.
12. Yes, lordship. Your lordship, I may be allowed to read the relevant part.
Yes.
Yes. Offenses which involve moral turpitude, grave offenses like rape, murder cannot be effaced by questioning the proceeding because that will be a harmful effect on the society. Such offenses cannot be said to be restricted to 2 individuals or 2 groups. If such offenses are quashed, it may be send wrong signal to the society. However, when the High Court is convinced that the offenses are entirely personal in nature and therefore do not affect public peace, and where it feels that quashing of such proceeding on account of compromise would bring peace and would secure ends of justice, it should not hesitate to quash them. In such cases, the prosecution becomes a lame prosecution. Pursuing such a lame prosecution would be a waste of time and energy. That will also unsettle the compromise and obstruct restoration of peace, lordship. Your lordship, now the parties have already settled and they have already compromised between the.
Okay. How the case arisen?
Your lordship may kindly see my annexure 1, page 11, lordship.
Page 11.
Page 11, annexure 1. For more clarity, you kindly go to page 12. That is the type copy, lordship, of the
Yes.
FIR. Yes. This is the FIR. I have the honor to state that about 8 a.m. today, so-and-so, a truck unknown coming from Imphal hit my nephew, Shri so-and-so, and ran away. However, nearby passerby and residents saw the incident and reported to us. On the report, the suspected truck was chased and intercepted at Kohima and now under police custody. Now, your lordship, basing on this FIR, 3 accused persons were arrested. 3 accused persons were arrested.
Okay.
Now, while they were in the judicial custody, the complainant, the owner of the vehicle, and then the victim father that entered into a compromised state, which the owner of the vehicle had compensated the victim family. And then they have made
Victim, out of this accident, victim injured or
yes, victim was injured, lordship.
injured or not died?
Yes, not died, injured.
Okay.
So the owner of the vehicle, the truck owner of the vehicle had compensated. And then accordingly, they have entered into a compromised state. Lordship, may kindly see my page 14, annexure 2. This is the compromised state which was met between the.
So what is the status or the condition of the victim?
Lordship, now after medication is fine.
It's fine.
Yes, Lordship. So they have entered into an amicable settlement, Lordship.
Okay.
Now, Lordship, after the
Heard, Mr. You are Mr.
Tushitamjan,
Hmm?
Tushitamjan.
Line counsel for the applicant petitioner. So there is no respondent.
Yes, Lordship.
Okay, stop. Para. You write two, huh? No. This is an application under section 482 of the Criminal Procedure Code 1973. Filed by. No, this is a joint application. This is.
Yes,
This
yes,
is a
Lordship.
joint application, huh? Filed by there are three person.
Your Lordship, initially 3 persons was arrested in connection to this case. However, after the charge sheet, while taking
So
cognizance.
in the settlement also, these 3 persons have put their signature.
Yes, yes, Lordship. Lordship, may kindly see my annexure 4, page 21. Not only with the owner of the vehicle, but also with the accused person, they have also entered into a compromise state. Annexure 4, page 21.
Okay. This is this is an application, huh? Under section 482 of the criminal petition, the Criminal Procedure Code 1973, jointly filed by 3 applicant, namely Sri Suresh Rai to Sri Suresh Rai, huh? Within bracket. Accused. Number 1. Number 2, Sri MD Ajayruddin. Accused number 2. And Sri Akobi Sabi. Who is this?
He is the complainant, Lordship.
Okay, within bracket, informant. He is a victim.
No, Lordship,
No,
he is the
informant.
complainant. Yes.
Where is the victim then? Victim has not filed.
Yes, Lordship, Lordship may kindly see the annexure 2, page 14. Your Lordship, the victim.
No,
The
victim.
complainant is the uncle of the victim.
Uncle.
Yes.
The victim is a minor.
Yes, Lordship.
Huh?
The victim is the minor. And then the complainant is the.
Who represent this Akobi Sabi, who represent the informant, who represent the victim. What is the name of the victim?
Tusuvi Savi.
Tusubi Sabi. Tusubi Sabi. What is his age? Minor.
Yes.
within bracket minor. Stop. But stop. By filing this application, the petitioner prays for washing and setting aside the criminal proceeding stroke trial pending before the learned judicial magistrates first class, Kohima, Nagaland. The criminal proceeding trial of the GR case, GR number 47, 2023, arising out of Kozama PS case number 04, 2023, under section 279, 336, 337 IPC, read with 184 MB Act before, pending before the learned judicial magistrates first class court, pending before the court of the judicial magistrates first class, Kohima, Nagaland. Stop. Para 3. The case of the petitioner is that on, what is the FIR?
At page 12, Lordship.
This is on which date? It was
4/3/2020.
on 4/3/2023. A written FIR was lodged before the OCPS, Kozama Traffic Police, Kohima, Nagaland, to the effect that by the petitioner number 3, within bracket Akobi, by Akobi Sabi, within bracket petitioner number 3, to the effect that at about 8 a.m. then on 4/3/2023 at about 8 a.m. a truck number unknown, within bracket unknown, coming from Impal, hit his nephew Sri Nokedu Sabi and ran away. Stop. However, the passerby and the resident nearby saw the incident and reported to them. On the report, the suspected truck was chased and intercepted at Kohima, and now Kohima, and brought to police custody. Stop. On receipt of the said written FIR, the case was registered, being Kozama PS case number 4/2023 under section 279, 336, 337 IPC, read with 184 MB Act, and arrested Sri Suresh Rai, petitioner number 1, and Mohammad Azharuddin, petitioner number 2. Stop. While they were still inside the custody, this agreement was entered.
Yes, Lord, Your Lordship, while they were in the judicial custody, the owner of the vehicle had taken the initiative and then that compromised with the victim family.
The case was investigated into.
Lordship.
Whether the case was investigated, charge is filed.
Yes, yes, Lordship,
Okay.
charge sheet already filed, Lordship.
Okay, the case was then investigated into and submitted into charge sheet against the accused, against the petitioner number 1 and 2. Have you annexed the charge sheet?
Yes, Lordship, may kindly see page 17.
Submitted into charge sheet against the petitioner number 1 and 2. Under section 279. There is another accused also, Alip Khan.
Yes, Lordship, that is what I'm saying. Initially, 3 persons were arrested.
Ah.
However, after the charge sheet has been filed, while taking cognizance, Mr. Alip Khan, he was discharged from the liability as there was no prima facie.
Who is Alip Khan?
Your Lordship is also one of the accused.
The accused, but what was his role? Owner, driver?
No, no, he was just a passenger, Lordship.
Okay. Then arrest would be 3 persons, huh? Arrest would be 3 persons. Arrested. The accused number, the petitioner number 1, 2, and 1, Sri Alip Khan, huh? Within bracket passenger. Oh, stop. Okay. Then come back here. Submitted into charge sheet under section against the petitioner number 1 and 2 under section 279, 336, 337 IPC read with 184 MB Act. However, the co-accused Alip Khan, as there was nothing against co-accused Alip Khan, the IO prayed for his discharge. From his liabilities. Stop. Huh? So what is the case pending before the case number?
47 of 2023.
Accordingly, the CJM took cognizance of the case and endorsed the JMFC. It's endorsed to JMFC.
No, Lordship.
JMFC is the, okay, it was submitted before the JMFC only?
Yes, Lordship.
Okay.
Yes.
Accordingly, the JMFC took cognizance of the case and registered being, what is the register, being?
GR number 47 of 2023.
Okay. Register being, register a case being GR number 47/2023. Stop, huh? Fair. The further case of the petitioner is that during the pendency or during the when the settlement arrived, 4/3. On the same day. No.
No.
When the settlement arrived?
Your Lordship, the compromise was met on 3/4/2023.
3/4?
Yes.
On the next day?
Your Lordship, on the next month.
On next month?
Yes.
Next month, they were still inside the custody?
Yes, Lordship.
They were still under custody?
Your Lordship, after the accused person were arrested, the owner of the vehicle, the owner of the truck vehicle had approached the complainant family. And then they have executed a compromise state.
No. So when the compromise, the settlement was entered into, whether the accused was still inside the jail?
Yes, Lordship.
For such a long period?
Lordship, actually bail was granted. However, due to some bailer and not, they were not able to come out on time, Lordship.
Okay, okay. The further case of the petitioner is that while the accused, while the petitioner number 1 and 2, along with 1 and 2, along with the petition, along with one Mr. What was his name?
Alif Khan, Lordship.
Khan. No?
Yes.
Alif Khan were still inside the custody. Compromise deed was executed between whom?
The owner of
The informant.
Yes, yes.
The informant representing the victim. Informant who is the brother of the victim, and who is the brother of the victim and who represent the brother and represent the victim, huh? And the owner of the vehicle.
Yes.
What is his name?
MD Amul, Lordship.
MD
Amu.
Owner of the vehicle. Stop. For settling the matter amicably between the parties. Stop. The deed of the compromise deed is the relevant portion of the compromise deed is reproduced herein below. Stop. This 1, 2, 3. That I had lost so and so because I was that my nephew so and so. That was register this case so and so. Up to 4, huh? So what happened thereafter? You approached the trial court.
No, Your Lordship, since 2 of the sections are not compoundable in nature, that is why the petitioner has been approaching this honorable court, Lordship.
So this was presented to the police also?
Yes, Lordship, yes.
Okay. So the above compromise deed was presented to, was submitted to the IO of the case, as well as in the JMFC also?
Yes, Lordship.
And before the JMFC also. However, since 2 of the section, that is section 279 and 336 IPC were not a compoundable offense, the petitioner filed this petition under section 482 of the Criminal Procedure Code, praying for quashing and setting aside the GR case, GR number 47/2023, pending before the Learned Court of Judicial Magistrates First Class, Kohima, Nagaland. Stop. Huh? Yeah. This is the only settlement order, settlement copy.
Your lordship, again, go to page 21, annexure 4. Annexure 4. Your lordship, after the accused person. Page 21, lordship.
21 is annexure 5.
Yes, lordship.
Hmm?
Your lordship, after the accused person were being released from the custody, the accused person had also made a compromise between the.
Same thing.
Yes, same thing.
Repeated the same. The terms and condition is same, I think.
Yes, lordship.
Okay. So then this is to be before filing of this petition before this court. Now, subsequently, before the paragraph which says that since the two of the section is not compoundable, before that, and subsequently after the release of the two accused person, release of the accused persons, within bracket petitioner number 1 and 2, comma, an affidavit was executed. An affidavit was executed by the informant petitioner number 3 and the accused petitioner number 1 and 2. 1, 2, and Sri Alip Khan. In presence of the competent witnesses to the effect that competent witnesses, the said affidavit reiterated the earlier deed of compromise deed dated when this was 3/4/2023. Same contention or something different? Or
no, lordship, same contention, lordship.
Okay. Stating that, declaring that the compromise deed has been entered between the parties for settlement, for amicable settlement of the case pending before the Learned JMFC. Kohima. And a compensation has been paid to the victim family in return for which the informant has agreed to withdraw the complaint stroke FIR lodged against the accused persons within bracket petitioner number 1 and 2. Stop. And since that, then that will come. And however, since the 2 of the section is non-compoundable, the petitioner filed this application under section so and so before this court praying for set quest and set aside, that will come. Stop. by an order dated by an order dated 15/12/2023. While taking note of the deed, compromise deed enclosed as annexure 2 to the petition, in order to verify the authenticity of the said compromise, this court directed the petitioner to appear before the Judicial Magistrate First Class, Kohima, Nagaland, on 17/1/2024. With a further direction that with a further direction to the learned Judicial Magistrate First Class, Kohima, to verify the authenticity of the compromise deed and to submit the report before this court by fixing the matter to be listed today. And in the meantime, the further proceeding in connection with GR case number 47/2023, pending before the Judicial Magistrate First Class, Kohima, Nagaland, has been kept suspended till the next date. In compliance of the said direction, the learned Judicial Magistrate First Class Kohima has submitted a report with along with the order sheet, along with the extract of the order sheet. And I have perused the same stuff. This report is also a little long. It's taking a long time. The report, among other, states that the compromise deed dated 2/4/2023 between the informant informant petitioner Mr. Akubes Sobi, petitioner number 1, stated before the learned JMFC that the said compromise deed was executed voluntarily and without any coercion. And on examination of the compromise deed dated 2/4/2023, the same was found to be authentic. Same was found to be correct as it was as the same was correct, as the same was authenticated by the chief judicial by the then chief judicial magistrate Kohima on 24/2023, bearing registration number 227/2023. The subsequent affidavit executed on 10/10/2023 between the informant and the accused persons were also found to be authentic. It was also found to be true, as it was also authenticated by the Notary Public bearing registration number 437/10/23 dated 10/10/23. The informant, petitioner number 1, also affirmed that the said second affidavit was also executed by them with the accused persons voluntarily and without any coercion. Since the accused, without any coercion. It is also, the report also contained that the accused persons and the owner of the vehicle have adequately compensated for the treatment of the victim to Sobi Sabi and Nokebi Sabi. Which has been authentic, which has been found by the father of the, which has been found by Mr. Tosobi Sabi, the father of the victim. It is further say that, no, so just a minute, okay. In view of the above report, in view of the above report, I'm in view of the above report and sorry, not in view of the above report, the in support of his submission, land counsel for the applicant cited the judgment of the honor of the Supreme Court reported in 2014 9 SCC 653 within bracket Yogendra Yadav and others versus State of Jharkhand, and another stop. The relevant portion is reproduced here in below. So these para 4 and below It starts from, I have marked it, huh? Okay. Up to this. Then counsel for the petitioner. Counsel for the, counsel for all the petitioners. Staff, various staff. Also, various staff. Records and the contents are made in the petition. Stop considering the submission, considering the contents are made in the petition and the submission made by the land council for the applicant petitions. And also on and also considering that the parties has entered into an amicable settlement of the case outside the court. And victim has adequately been compensated by the alleged accused within bracket petitioner number 1 and 2. I'm of the view that the continuation of the GR case number 47, 2023 before the JMFC court, Kohima, would I'm of the, what did I say? I'm of the, okay, would not serve any purpose in view of the above fact and circumstances of the case, and also the decision of the Supreme Court. Accordingly, this petition is allowed. As a result, the GR case number 47 arising out of Kohima PS case number 4, 2023 under section 279, 336, 337 IPC read with 184 MB Act. Pending before the Land JMFC Court, Kohima, Nagaland. They set aside and request. The petition and the accused number 1, accused Mr. The Land JMFC shall pass necessary order for discharge of the accused Sri Suresh Rai and Muhammad Azharuddin from the above GR case number 47, 2023 Kohima PS case number 4, 2023 arising out of PS case number arising out of Kohima PS case number 4, 2023 under section 279, 336, 337 IPC read with 184 MB Act. Stop with that. This petition stands allowed and disposed of. Okay.
Lordship, my name may reflect.
Oh, yes, you are for?
State, Lordship.
State has been made as a party?
Yes,
Yes, Lordship. I thought no, because.
Anyway, Lord, in any case, I'm just going to leave it to your discretion in view of the authentic.
Sorry, because I only saw the name of the, the petitioner, only petitioner. I did not see the respondent. There is also respondent.
State of Nagaland.
Okay. So in the, after his submission, Mr. J. Angami, na?
K. Angami.
K. Angami, appearing on behalf of the state, has submitted, he has no objection.
Lordship, in view of the authenticate,
Okay, submitted in view of the authentic, in view of the report submitted by the JMFC Kohima, where the authenticity of the settlement deed has been confirmed. He has no objection. If this no objection to the compromise settlement of the case. Okay.
Lordship.
One more item. We'll come back. Council is present.
No, I think this time they should be here in the coming night.
Will come after few minutes.
So I don't think they will come.
Yes,
I don't think they're coming, so they do then.
So he is not coming. The council is not there. Okay.
They should be
Then,
here.
list it tomorrow or day after tomorrow. Okay. Item.
Number 30.
No one appears on behalf of the, no one appears when the matter was called for. Leave this matter next week. Yeah. Okay.
Stop swimming.